Hey guys, I think I got this thing started again. It looks like the trial is still not on, which is good. And I put this up on comments in case I happen to miss it. If it does come on, you can tell me. Because I'm going to look down at the iPad here for a minute. So a couple of things the judge keeps referencing I thought would be useful to talk about. First is 90611. And that's a Wisconsin statute that gives the judge authority over how she proceeds in the courtroom, how she will control the proceedings, order and pace, and things that can happen or not happen. But she also talks a lot about Illinois versus Allen, which is a Supreme Court case. Talks about the removal of a defendant from the courtroom during his trial. So there was a guy who was terrible, maybe even worse than Brooks, during a trial and completely disruptive. The judge finally removed him. And the Court of Appeal said, hey, you can't do that. He has to be in the courtroom during his proceedings. Even if you have to bind him and gag him, he still has to be allowed in the courtroom. So it went up to the Supreme Court, and they said, no, that's not true. They said, we accept the statement of Justice Cardozo, who spoke for the court, saying, no doubt the privilege of personally confronting witnesses may be lost by consent or at times even by misconduct. And then they say, that you can lose that right if you insist on conducting yourself in a manner so disorderly, disruptive, and disrespectful of the court that the trial cannot be carried on with the person in the courtroom. But, and this is why you hear this judge can continue to say this, once lost, the right can be to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. So that's why this judge ask him that. That's why she's so hesitant to keep him out of the courtroom, because just because you get kicked out doesn't mean you can be kept kicked out if you gather your wits back about you. So that gives me a little more sympathy for her position, although I think he was out of control this morning, in my opinion. So the Supreme Court said trial judges confronted with disruptive, defiant defendants must be given sufficient discretion to meet the circumstances of each case, and no one formula will be appropriate in all situations. But there are at least three. They didn't say there are only three, which he's trying to say. They said there's at least three ways to keep them from disrupting the proceedings too much. And one is to bind and gag the defendant. Think about that. So they haven't done that to him, but in theory they could. Of course, he's representing himself, which would make that tougher to do. But he could still be present in the courtroom. You could cite him for contempt, which she's talked about, but which, of course, would be pointless with a nut like this. The third is take him out of the courtroom until he promises to conduct himself properly. Now, this case is quite old, so she's made the point that when he is removed from the courtroom, he is still able to participate in the proceedings. He's taken to an alternate courtroom. He's given his materials. He's given audio visual. He's given the ability to object or even to speak as long as he's not being disruptive, but it allows her to mute him to effectively gag him without gagging him while she does the things that she needs to do. So I think she's well inside the Supreme Court decision by the process that she's decided on. And this is why she keeps harping back to it. I think, obviously, that you have to be very careful there, that he hasn't regained his senses and decided he would play ball in an orderly way. And this is also why she keeps talking about decorum. Like, is this a finishing school or is this a courtroom we've got business to do? But it's because, I'm sure she believes in it, but also it's because it's part of the Supreme Court language. So it needs to be in the record as she moves through the trial. So that's the Illinois versus Allen case that she cites all the time, in addition to 90611 as her authority to remove him from the courtroom. And of course, is that a lawful law? I think it is, because it's a Supreme Court decision. So I'm going to go with yes on that, as well as the Wisconsin statute. And of course, the laws we are primarily concerned with are the lawful laws. He's got a good point there. When she's citing a law, it's very reasonable to say, Your Honor, is that a lawful law? It's not a thing I've ever done in court, but then on the other hand, I'm no Darrell Brooks, right? And this guy, he knows what he's about. He knows what he's up to. So I think he could have been removed out of the courtroom today more than once, and probably, in my opinion, should have been, because he was being highly disruptive, insulting to the judge, shouting her down, yelling at her to stop it, refusing to conduct proceedings, etc. And maybe they should have spent a little time shutting this guy down earlier. That's just my opinion. She's in a tough spot. I can't say that I would have done any of it any better than she's managing to do it. But, it's infuriating to watch, and you wish that some order would be restored there. I think his conduct is not what I would have expected a judge to tolerate, or even DAs, for that matter, would have more to say in the good old days. Maybe they were good and maybe they weren't, but nut jobs like this, could be dealt with to some degree. Well, he can. I mean, he can be taken out of the courtroom. So if I were going to be sympathetic to the guy, and I'm not because I don't think he should be breathing, but if I were, with all the carefulness that the judges exhibited yesterday, she was pushing him to be done by the end of today. That would basically be a day and a half for a defense in this 6 capital count or murder count case with 70-some charges. And that does seem very tight when the prosecution has gone on for longer than that, even not counting his disruptions. So I was surprised that she would have pushed him that much to be finished in a day and a half. And I don't think that's going to happen either, right? But otherwise, she's been extremely careful to support the constitutional rights that he has in the way that the court has decided to interpret them, because it's all just interpretation, because the Constitution is pretty vague, very short. It wasn't meant to be a set of detailed regulations. It was principles that would be interpreted and enforced. So you get these contrary thoughts on what does it mean to be able to confront your accuser and have a fair trial. And the Supreme Court clarified it doesn't mean you just get to sit in the courtroom and yell negative things to the judge and disrupt the proceedings, that the court can handle that. If that's the way you want to be, then in that case, you can be restrained, taken out of the courtroom or whatever. Now, that's different, of course, than somebody who's not competent to stand trial, because then they would suspend the trial. This is when you have someone who is apparently competent to stand trial, but one of their motivations in their behavior is to disrupt the trial and to not have it proceed in an orderly fashion. And that's certainly something Brooks has done. It's been very, very crazy to see him questioning witnesses that are totally detrimental to his own case. And again, wondering whether he just named people to try and get to this magical 13 number that he wanted. It seems to me that so far the only one he's called that he has an interest in is Erica, and his interest there is, I think, several-fold, and that's why his emotions probably ran higher. One is he has a history of dominating and beating her, and that's pretty much excluded from the jury's knowledge right now. Witnesses have had to dance around it. He's trying to exploit that by saying, well, she has no reason to be afraid of me, of course, she's a liar. But the jury has not heard his past conduct to her other than the abuse that's charged in this case. So he's gotten a benefit of that, truth being withheld. Remember, truth-seeking function is only part of what the judicial system does. They don't throw all the truth out in front of a jury and say, you make the call. There's a lot of decisions made before the jury hears any evidence as to whether to be allowed in or not, and the decision does not always turn on whether it's relevant or whether it's true. So he's a benefit of truth being withheld from the jury at this point and trying to exploit it. So I think he also blames her because he was in a fight with her before he turns around and runs through this crowd. I don't have any doubt to me at this point that he also blames the people for not getting out of his way. I mean, he blew his horn. What else is he supposed to do? Kind of like he beat this woman because she didn't give him as much money as he thought he should get from her. I mean, what else is he supposed to do, right, in his mind? So it's her fault. He likes dominating and attacking women. That's a thing that he enjoys, apparently, and he's done it to the judge. You know what he would do to that judge if he had a chance to do it, worse than he's done to Erica. He wants to humiliate Erica on the stand. Some of his questions were driving toward that, and he got to do that a little bit, in my opinion, yesterday by making snarky kind of faces while asking the judge to strike things and stuff like that. And I think he thinks he'll be able to get away with it today. So here, he's been removed from the courtroom. I'm going to bring the judge in here. And
morning, to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and
I'm getting an echo in my headphones. If you guys don't hear that, and I'm going to let this baby rock like it is. It could be coming from the courtroom. I don't know.
In that regard.
Let's see what she says.
Part of this morning dealt with his, from my perspective, disagreement with how I, yesterday and in the days preceding that, set up
life
what
path.
I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, excuse me,
I don't think
serve
they want
subpoenas
this
on
to
his
happen.
behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly my obligation under 906.11, to make sure that there is an effective presentation of evidence, and exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because
So he's reading the Bible just to show the judge
into
he's
the record
ignoring
once
her.
again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the
So
case.
he was kind of
including
opening the
credibility.
door to that.
In
There's
the
a
interest of
notion that
justice, the
even if
judge may
something is
limit
relevant,
cross-examination with respect to matters not testified
if
to
it's
on direct
if it's
examination.
prejudicial, well, that's the
The
point
next
of evidence.
section,
You
leading
enter
question.
evidence that you think is
Leading
prejudicial to
questions
the
should
other
not
side,
be
but there's a
used
concept of
for
unfair
direct
prejudice,
examination of a witness,
that it would be
except as may
outsized
be
prejudice
necessary
to the
develop
defendant
witness's
to allow it,
testimony.
and that's how it's been so
Ordinarily,
far,
leading
I think, and that's why
questions
she
should be
doesn't want to
permitted
open
on
that up.
cross-examination. And then the next part talks about
He's
civil
trying to make sure
cases.
everybody knows he doesn't pay attention to
would not
women.
be applicable
Women
in
don't
a
tell
criminal
him what to
case.
do. They have to
So
ask.
that
He
is
decides.
a statute that guides what I do, not just in this case.
Yeah, he's got his mask
but in
back
every
on too. The
case
mask is extremely
that comes before
situational.
me
Everything's a
for
prop to
trial.
him, including women.
Or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement.
Very fair.
I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses,
Well,
those
holding
of the
him in
victims,
contempt
and of course,
wouldn't accomplish anything
last
with a
but
nut
not
like
least,
this.
the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break.
Which
That's
it
why I
is.
brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to.
So we did go over
I
Illinois
couldn't
versus
tell
Allen
you
at the beginning of
everything
this.
that was said
It
at
does
that
give a
time.
criminal defendant a little more leeway to be a
One, I think
butthole
it's
than it would
important
an
to know,
attorney,
though, it's
but not unlimited.
The tone, the demeanor, the decorum, or frankly, the lack thereof. For many days.
And
on
decorum
end
is right out
throughout
of
this
Illinois
trial.
versus Allen.
It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction.
Her job is quite stressful the last week and a half, probably longer than that.
Well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay,
True.
and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted.
Mm-hmm.
I brought him, I should state it this way, he is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay,
This is a great point.
interruptions, disrespectful behavior, the common courtesy, I think that just as a human being we all would expect, have not been followed. It's evidently made, let me restate that, it is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And
Yeah, he did this in his interrogation as well. He would just change topics and then argue down rabbit holes.
Issues that are before this
Just what he does.
And then tries to divert things down a different path, whether
Right.
that's to delay.
Normally with
to
a woman, he would
disrupt,
just punch her, but he can't do that here, so he has to do these
or
stupid
just
arguments.
simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record, not off the record,
Look at
I
him.
actually dismissed
This
the
guy's
jury
nothing but a
in
show.
order to try to get an offer of proof from Mr. Brooks. And as that
I feel like it's finally
exchange
time
went
for that.
on, it got, from my perspective, he got louder,
And
he got
this
more
is true.
disrespectful.
But it doesn't mean he has to be
Fair to
indulged.
say, his
to an
behavior
infinite
was
degree.
volatile, and it's
Of course.
because of
I
that
know you know that,
I
and I'm
called
just
an
saying that.
early
He's
lunch.
had it with this guy.
And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record.
So in Illinois versus
Like I
Allen, the
said,
guy actually
it's
threatened to kill the
challenging.
judge, but
That is why he is in the other courtroom.
he didn't constantly do that. He
muted,
just
so
basically
that
stopped the
I
proceedings
can
by
make
never
the
stopped
record. I
talking,
will
kind of like
confirm with
Brooks.
my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how
Looking
to call
at
witnesses.
Illinois versus Allen,
He
it
pushes the
specifically
limits
says the
on
court doesn't need to hold somebody in
asking
contempt if that's
questions
just
that
a
are not
tactic by the
probative, that are
defendant
not
for more delay.
relevant. or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and...
So talking about the prior acts here, again,
question,
remember,
basically?
the truth is
Their
being withheld
nonverbal
from the jury
communication to me, or
for
some
Brooks'
have actually
benefit
said,
that he
"I don't
has
think I
beaten
can answer that." There
Erica
have been other
multiple times in the
witnesses
past.
where I've stopped them from answering so as not to bring in the other acts evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906.16 and 906.
Illinois versus Allen says it would degrade our country and our judicial system to permit our courts to be bullied, insulted, and humiliated, and orderly progress thwarted and obstructed by defendants brought before them charged with crimes.
From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that.
I'm sure this is
Only
true.
about opinion evidence, their opinion
But I
of the
think,
person's
I don't know what
character
more
for
convincing they need other
truthfulness.
than the real evidence of the case, which he said
Under
in his
bias, 906.16,
teary-eyed
didn't see
opening
where it
statement
also
where everyone
related
was
to,
supposed to feel sorry for him, that he wasn't going to
credibility.
contest the facts, just to keep an open mind
Says,
and
for the purpose of
understand two
attacking
sides of the
credibility of a
coin.
witness, evidence of bias,
It wasn't
prejudice,
intentional or
interest
whatever,
of the
cried for
witness
himself,
for or against
and
any
went
party
back to
the
bullying
case
people
is
again.
Admissible. Again, simply attacking her on her motherhood.
I think he's trying to
That's
show
my
here that
perspective.
she contacted him after
Did not receive
the beating
answer
event, which would
to
then
the
be
repeated
contrary to the
questions I
theory
asked
that
regarding
she's
the offer
afraid of
proof,
him, which
and this letter
the
that
DA
he
says,
claims
well, then she should be able to explain
was
why
sent
she is
by
afraid of you, which
Erica
includes the fact that you have a
Patterson,
history of beating her,
and then
which
the
they have
photos.
not let the jury know that
The
yet.
issue, as it relates to this witness, is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason.
He
as
won't
to
like
why
this
it's
because he wants to
relevant.
humiliate Erica.
The state also, I think, rightly points out that if those questions were to be answered by Erica Patterson and other questions along those lines.
You know,
that were
in his music
questions
video, I
that
didn't
were
notice him
objected
reading the
to
Bible as much
by
as
the
he seems to
state
do in
that I
court.
sustained.
Maybe that's a different
Mr.
video.
Brooks would open the door to what only could be described as very damaging evidence against him related
Kaboom.
to the other acts evidence,
Yes.
related to whether he has a relationship with the children or not, and frankly, a topic I am not going to open the door to.
Good.
I'm not
Correct.
going to allow. It's a side issue. It is not relevant. It is not probative.
Leave the kids out of it.
but certainly one could argue, based upon the questions, topics that the door could be opened to.
Imagine being so gangster that you have to use your mom's car in
It is
your
my
rap video.
duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses.
He has a constitutional right to represent himself as long
And
as
so I'm not going to
he's competent
allow
to do it.
questions related to the children in common or child in common, at least any further between Mr. Brooks.
And I will say
Ms.
that competence to
Patterson,
stand trial and then
when they
competence
met,
to
how
represent
they
yourself,
met,
there's
the
only
nature of
short
their
distance
relationship
between those
now,
two.
whether
Once you're
there's been
competent
any
to stand trial,
contact
it's basically,
between them
but you know
since
what's up
he
in
was
court here,
arrested
you can
and going
concentrate, pay
forward.
attention. I mean, you're basically going to be
Because
allowed to
nothing
represent
that
yourself
I've
at
been
that point. You don't
presented
have to be
with
good
would
at it.
suggest
It's your
it
choice to be an
relates
idiot.
Not only to relevant and probative information, but even to her credibility as a witness.
Yeah, it's super awesome to be punching your ex-girlfriend
I
for
will give
money
Mr.
and driving your
Brooks
mom's
a
truck
final
around.
opportunity to make an
He
offer
thinks
of
he
proof
is
as to why
such,
he
and
believes
he is
my
certainly
decision
not.
is wrong. That needs to include an offer of proof as to why he believes this letter
Oh, God.
is from Erica Patterson,
Not back
and
to
why
this again.
it's relevant to
But
the
did he
issues
even
in
get it
this
from his
case.
cell? Who knows? Now, that temporary laborer guy yesterday, that's a badass. There's lots of reasons why you may end up on temporary labor, but I hope he
Because
gets
he came in to the
a
courtroom
job that's
this
different than that,
afternoon
because
and is not
pretty
in
stand-up
here,
guy.
but in an adjacent courtroom. I want to make
Could
some
do well,
additional
deserves to
findings
do
as
well.
well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in
Here
our
comes
country.
the Illinois versus Allen that we
Flagrant
talked about.
disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated.
So he could plead insanity, because whether you're
Trial
insane at
judges
the time of the
confronted with
crime
disruptive,
is completely different whether you're
contemptuous,
insane now
stubbornly defiant
and whether you're
defendants
competent to stand
must
trial
be given
now. So he
sufficient
could do
discretion to
it.
meet the circumstances of each
In theory,
case.
I guess he should have
No
done
one
it already, but
formula
I
for
don't know what
maintaining
the rules are on
appropriate
that.
Courtroom atmosphere
She probably
will be
would let
best
him
in
if he
all
wanted to.
situations. This court has utilized
But he didn't
an
say that. He
adjacent
just said it
courtroom
wasn't intentional.
with superior audio and video capabilities that I believe are the
Yeah,
functional
she hasn't been able to pull
equivalent
herself out of his
being
orbit, and
present
it's unfortunate.
in this
She seems like a
courtroom.
nice person.
Mr. Brooks'
Hopefully this will be the
behavior
end of that
today
for her.
alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There
Now,
was
if you
nothing
choose to represent
orderly
yourself
about it.
and you're bad at it, that's not a violation of your Sixth Amendment rights. You don't get to
I would
represent
remind him
yourself and
once
go, well,
again
it turned out I
of the
sucked. Let's do it again, and now give me a lawyer.
SCR
Doesn't work
Chapter
like that.
62, which are the basic
He would need to demonstrate that he was incompetent to stand trial, and that's not going to
courtesy and
work.
decorum in the courts in the state of
He's
Wisconsin.
examined people. He's made arguments. They're dumb arguments, but he's made them
Remind
consistently.
him of the golden rule. Do unto others as you would have them do unto you.
And she's going above the
Be
Supreme Court.
respectful. Be kind. Give these proceedings the due respect that they deserve for himself. I do not believe he even shows respect for that.
Oh, man.
I'm not looking for any further input on the issue of removal. or
Prisoners
any further
represent
record.
themselves on appeals all the time,
Wanted to
sure.
Make that record without
All the time,
interruption,
not only
which
to the
is why
state
Mr.
courts, but they
Brooks
write, writs to
was
the
in the
federal
other
courts trying to get released under federal law and stuff like that. I remember the funniest one I saw was one time
When we
somebody
come
filed a
back
motion to
this
set the record
courtroom,
straight.
I will ask Mr. Brooks for an offer of proof. He will be brought in.
So he's going to get to
So
talk
we'll
to her
walk the
about this
record for
letter
that
and try and
momentarily.
express to her why it's
We'll offer
relevant.
proof if he wishes to do that related to the letter.
He didn't really want to
further
talk too much about that letter
I
last time,
also
other
want
than
an
to say
offer of proof as to what
I should
probative
be
and
allowed to
relevant
bring it in.
information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself.
this is true, but he was told
The
you don't
vast
know all the
majority
things you think
of
you
the
know.
testimony today
You're exposing
has been a
yourself to risk.
rehashing and a
You know, he's not entitled to
of her
a
testimony
legal education
from the
before he
other day.
represents himself.
From-
He was apprised of the risk. He made
Take a look
a
at my
decision.
notes for
He
the
is an
date.
idiot, and he's
October
going to
what?
represent himself as an
October
idiot.
7th, I believe she was the
And
third
that's
witness.
not reversible error.
We did not glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here.
So if
With
they don't
that,
cross-examine her
I am
and
going to
he
take a
says, I
very
don't have any
short
more
recess
questions, that's it for her.
to have
If
Mr.
they
Brooks
cross,
brought back
he'll
into
probably be
this
allowed to
courtroom
redirect.
so that
So
we can continue with
it's going to be
testimony
showtime.
and
She brings him back into the
Thank you.
courtroom to see if he can conduct himself with the appropriate decorum as the Supreme Court requires, or else she could boot him out again. And we'll see about that. So while we're looking at the Eagle, we'll talk a little bit again about, we did look at Illinois versus Allen, the Supreme Court case that she's been referencing, and the requirements that it has if you boot somebody out of a courtroom, because it's right on the edge of the Sixth Amendment. You know, you can't confront your accuser and have a fair trial if you're not allowed to be there. But you can be kicked out in certain circumstances. And the decision itself, although it's quite old, said this is not a formula. There can be other ways. Technology has marched on since then, and they're able to put him in another courtroom where he can see and hear and have access to all his materials. He's just muted when he's being disruptive. People didn't have their own laminating machines back when they decided Illinois versus Allen, and they do now. So he can have his personal objection sign. I wish she had a laminated sign that said overruled, that she could hold up back to him instead of having to say it, so she wouldn't be so hoarse. But she doesn't have that. She has to do it manually, old school. So the case that we went over, that's the one that she talks about all the time. And the issue in that case is, it basically says if the person is removed from the courtroom, as soon as they promise that they're going to conduct themselves with the appropriate level of behavior, the decorum, respect for the court, then you're supposed to let them back in. So she has to be careful to ask that of him. She has to be careful to make sure that she's not keeping him out longer than she has to. So that results in him being out, in, out, in. And that's a difficult situation for the judge because, again, in my opinion, she should have booted him out earlier today. But she's doing this all under the fly, under a lot of pressure. I'm not suggesting I would do her job better than her. Just frustrated by it like other people watching. Even though I'm a process guy, I also have an extremely negative reaction to this guy because he's just a murderer. And he doesn't care. He wasn't, I mean, I've spent time in a mental institution with somebody who was a mass murderer who was actually delusional at the time that occurred and not necessarily an empathetic person. But this guy, what's his excuse other than he's just vile and poorly formed human being? He regularly beats women, steals things from people. If she doesn't give him money, he punches her. And in a rage out after this confrontation with her, spins his truck around, drives down the road. Under his best case to me scenario testimony, he beeped the horn, and when these kids and stuff didn't get out of the way, well, what's he supposed to do? He just runs over them, right? I mean, it's their own fault, right? So I don't like this guy, and there's no penalty coming to him that I think is what he deserves to get out of this court system or any other way, no matter what happens to him in prison. So I don't like him, but he's entitled to his trial, and she's walking the line to try and make sure he has a fair trial without being too abusive to the process. and that she adheres to the Supreme Court guidance that's given on this, even though it has some flexibility. It's the line she's trying to walk. This case is obviously clear in that he did murder these people. He doesn't even say he didn't murder them in his opening statement. So it's, it's not like there's a mystery here. This is just a process you're going through in this case that is important a lot of times, to me less important here, because it's so obvious that he's guilty. And I'd like to shortcut to the future and imagine a world that he's not in. So, but I don't suppose that'll be the result of this. But unfortunately, I don't like him. I don't like him at all. I don't like him. So whatever. He ran over those kids, ran over the dancing grannies. He doesn't care that he did it. He doesn't care that he did it. To any degree that he was actually crying yesterday in his opening statement, which was completely bizarre, it was for himself. He couldn't spend those few minutes not trying to steer around and compare the great tragedy that the families that lost those people and those kids, those kids, they're never going to see another day, right? A violent death, and their family left with a huge hole. And all the innocent people that witnessed it, all the innocent people injured, in addition to the people that died, he couldn't spend the time on that other than to call it, a bad thing, tragedy, or whatever. But did you know that on social media, he's been called a monster? And this is what he's crying about, the depiction of him. And you need to keep an open mind and look at the other side of the coin. So what is the other side of the coin? He hasn't brought up another side of the coin. He keeps calling witnesses that are mostly people that he has either almost killed or caused to have surgery, or that are women that he's beaten before. And I don't know why he's calling them, other than he said it was really important to him to kind of get to 13 witnesses. Maybe that's some kind of magical number for him. So you just write names down and you call people who were great for the prosecution. Yeah, I saw you drive down the road and run over these people. That's the kind of people he's calling. So
that Mr. Brooks does not want to come over to the main courtroom.
Yeah, he's gaming the system
Mr.
again.
Brooks, I'm advising you.
He's
You are
constantly thinking about
invited
gaming the
back to
system.
this
If you don't
courtroom.
think that everything he does is
It's my
calculated
sincere hope that you
misdirection
want
and
to come
deception,
back here.
watch his interrogation with the police as he spins stories around
I see
while he
you're
asks them, well,
reading
what else are you going to
something,
investigate me before? Because he's
but
trying to
it's-
calibrate his lies to the situation.
We are at the point in this
That's all
trial
he
where
does.
you have a
Took
witness
his mother's
still
truck,
on the
murdered
stand,
people with
obviously
it, left his mother without a
figuratively at the
vehicle,
moment, not literally.
beats his girlfriend, steals money from her.
I'm going
This
to
is the
ask
kind of
you
guy
if
he
you are
is.
ready to answer my questions from previously, and also to let me know whether you
This was his argument in a nutshell.
are asking to stay in that courtroom.
Now, he will try and blame this on her. There's no point in me coming over there, Judge. You're
Been
just
advised
holding
to
me
come here and
essentially
see.
in contempt.
Mr. Brooks, we are on the record.
So, look, he will pretend.
I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like
Probably
to come back
blabbing,
here?
but she
Yes or no?
probably had the bailiff confirm the audio's on there.
The audio is on. Would you like to come back to this courtroom, sir?
You're unmuted. So I'm finally unmuted.
You've been unmuted for a while, since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
Yes, that's a good one. So here he goes, dragging it out.
Record to reflect, he's putting on the headphones.
Remember yesterday he pretended like he couldn't get it turned on for a little while. Just whatever he can do.
Mr. Brooks, I'm inviting you back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't saying nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
Not
did
held in
put you
contempt.
Then why am I even over here?
So that I could make a ruling and make a record without an interruption pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
Yeah, because you're on
Mr.
equal
Brooks,
footing with the
I'm
judge, you
asking
idiot.
you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
Sir, I
I
need
don't
to
wanna
continue with the trial.
I don't
So
wanna
if
keep
you
being
don't
held in
answer yes
contempt.
or no, then I will presume you want to be in that courtroom, and you'll,
Nice.
by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir.
You don't have to
So
consent.
I'll ask you
You
again.
idiot. You
Are
just
you
have to be
gonna hold me in
disruptive.
contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
See,
So
he doesn't
twice now
answer
I've
questions. He just
asked him, He has
misdirects.
not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
Good Lord. So he's going to come back over and quite possibly, of course, be disruptive again. It doesn't appear that he has decided to acquiesce to her authority. Instead, it seems like he wants to continue to be disruptive, at least currently, in a less loud manner. He's still mumbling. I can hear him in a microphone there, mumbling about contempt. Now, under Illinois versus Allen, remember there were 3 express ways a judge could deal with an idiot like this, and one was to bind and gag them, which if he had an attorney, you could do, and that would be cool. I'd like to see that. One would be to hold them in contempt, but they also say if the only reason a person wants to be held in contempt is simply to delay the trial, then that's obviously not effective for idiots like this. The third is remove them from the courtroom until they promise to not engage in the disruptive behavior, but behave with the appropriate decorum. And as soon as they promise that, you're supposed to let them back in. So that's why she has to keep asking this fool all the time. And so she's doing it. She's bringing him back over out of caution because of this Supreme Court case. If this case were decided now, I think it might be a little easier to say, well, just keep him over there. So, especially since he's so worried about COVID at particular times, right? He's not worried about COVID when he's giving his open statement or when he's asking questions of witnesses that he wants to mock. But he's naturally concerned about COVID at times when he wants to talk down to the judge. And he may have had his mask on at certain times. Other too, I saw him in the interrogation was wearing it down around his chin, which I think is 50% effective at reducing your COVID exposure. And it is advisable. CDC, I think, recommends that if you're beating your girlfriend to get her EBT card and her wallet, that you do wear the mask because you can have an exchange of a viral material in that way. Either it can go into the air or it can be exchanged on your knuckles if you're punching her directly in her face and she were to be COVID positive and didn't let you know that at the time you were beating her. Also, if you are in a parade ground and you're running over people and you're not staying 6 feet away because you are running over them, that's a danger to you as well. So it's good to have a mask on then. So, he tries to stay safe while he's killing and murdering people and assaulting people. At least he's got that going for him. I would like to see him physically gagged, but then I would like to see him gone. So it's interesting. I don't know that one way or the other just because I wasn't paying attention to that aspect of the case when this first started. Really thought this would just go in a normal trajectory, but it wouldn't surprise me, of course, if this is true. Yeah, exactly. So he's, again, fully consistent. So, of course, my real point there is the mask for him is a prop, like the Bible is, like the clothes he's wearing. That's a prop, right? She calls it street clothes for him. There's never been any street he's been on where he's been dressed like that I've seen. They can't have him dress like he normally would dress because that would be unfairly prejudicial. Kind of like he didn't want to show that music video that he did because of what he was doing in it. And they didn't play the lyrics to that, which I think is probably a good idea because it probably was nasty since that's what he is. That's what he is. Why is he like that? I don't know. Now, if you didn't catch this morning, I did hear that he wants to add his mother to the witness list because he claims that she's going to say that the detective who got the video from her backyard is lying about having talked to her, that he wants to call his mother to confirm his alibi. And there's not much more appropriate for this guy than calling your mother, right, to help you in this criminal case where you were driving your mother's truck. I think wasn't even living with his mother or something like that. A true success story. So he's just a great guy all around, taking advantage of his mother, using her assets, because I think she actually had something he's not very familiar with. It's called a job, and she was out earning the money that to have the truck that he was using. So, you know, that's what he is. Fortunately, I'm going to stare at his picture while they bring him back into the courtroom. For all we know, he could get back in there and have to be brought right back out again. Who knows? Yeah, I don't know. And I'm not saying you are. I just don't remember one way or the other. It certainly wouldn't surprise me if he did want it to be televised for whatever reason. Who knows with this guy? I know somebody mentioned before, you know, his rap name was Math Boy Fly. So he's certainly a scholar there in the science department, learning a lot of math that he's put to good use, I'm sure, and calculating how much money that the girlfriend should bring before he beats her. You know, she's not going to be able to wiggle out of that because he's able to calculate the sums on the fly and make sure that he's given the amount of money that he thinks he deserves from her, or he doles out the appropriate punishment. So I was listening in the background to her testimony this morning while he was questioning her. And of course, I was fully in a complete rage at this guy because he was obviously trying, not only does he blame her for everything, but he also wanted to humiliate her. And as the DA said toward the end of that, the problems she may have, he's a big factor in contributing to those problems himself. And of course, he raged out after that as well about her. And if he could, he'd like to get his hands on her again, but let's all hope that he doesn't have the opportunity to do that anymore. As somebody mentioned above, what he's facing here are life sentences without the possibility of parole if he's convicted of intentional homicide. And that's the minimum of what should happen to him. And for everybody's safety, he needs to just go away.
1248.
I don't know what his mother will say on his behalf,
All right, let's take up
but
the
she'll be
issue
better off
of
when he's in jail
the
as
letter
well.
and the photographs and your offer of proof, sir, if you have one.
I don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof
We
to
can go
provide,
past all
sir?
that. We can go past all that.
He don't need no
to ask
offer of
some
proof.
questions. It's too much of an issue. It's too much of a problem.
Yeah, too much of a
Mr.
problem.
Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just
to
said
the
no. I just said no. I just said that.
All right, thank you. Then based upon there being no offer of proof, then my decision stands. As to the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her
Sometimes you
probative
see a
and
defendant and you
relevant
think, how
testimony
could
will
that
be
person
from
have
this
done
point
that? And
forward.
he's not one of those
I
people.
mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
What topics generally were
He's
you
quite
going to
agitated.
question her about?
Wonder what happened to his jacket. Notice no belt.
I guess I'll have to look in here because so much that happened since over the past hour and a half or so.
Really? A lot of big
I can
events
tell you one
last
thing,
hour and a
I
half.
don't intend to have too many more questions. I'll tell you that. I was almost
I wish
finished.
that she
Need
could.
an offer of proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or
don't-
already covered by your direct?
I don't remember her. What do you mean by related to her direct? Is that from the last time she testified?
From the first date that she testified and from today?
I don't
What
remember.
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well, Mr. Brooks, this is your opportunity to prevent relevant and probative evidence, but under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about?
Boom.
when she comes back on the witness stand.
What do you mean by new topics?
That would be a topic
Topics that you
that is
haven't
new.
already covered.
What, to pursuant to the police report or something? Is that what you're asking? I don't understand.
I'm asking you, I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms.
I kind of scoffed at this guy's
going
acting
forward.
skills, but he, as dumb as he
You
is,
said related to
he actually
topics,
can
right?
pretend to be dumber than that.
You can just give me the topics, I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only,
Is it a statement that she wrote?
No, it's a police report.
I don't know if it's a statement that she wrote in here. Possibly is.
Do you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Guth spoke to her on both occasions, is that right?
Yes, with Detective Barrett with him on the first occasion.
I wonder who the guy sitting behind him is now. People vary, of course. Before there was that
Is
grandmother
he provided with
who looked
discovery?
disappointed.
What about the police report, sir? Do you want to question her about, so I know with specificity?
I hate this trial's interrupting his Bible study time.
Oh, I'm looking at it now.
Yeah, I agree. I think he holds her responsible for all of it. If she had brought the money, he would never have gotten angry. If he hadn't gotten angry, he wouldn't have hit her. He wouldn't have spun off, and he wouldn't have gotten in such a rage that he went into the parade ground. Then, of course, the people themselves are at fault because he beeped the horn. What is he supposed to do after that? It's their fault at that point. It's everyone's fault for him, except his. But I do believe he thinks Erica's the
did reports, 'cause it seemed
primary
like it's more than
driver.
just two. At least from this paperwork, is more than two.
May I have Bill show me what Mr. Brooks is referring to? I can maybe help him try and explain, but
Sure.
I don't know what
No,
he's
he's
talking
not
about.
falling for that dirty trick.
I can't find the first page to that, but whoever that officer is right there. I have to snatch it.
Don't have to snatch it. So he's even mad at the bailiff.
So I've got pages 2 and 3 out of 6 from Detective Barrett's report under Waukesha Police Department incident number 21-047533. This is one of the two reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
This is a good question here.
The report is
I'm
not
not
in
sure
order,
of their procedure there,
that's
but I
what
will
I
look
said
it up.
before. I would have
And
to
when this
read.
video is over later on, I'll leave a
Brooks, I trust that you're prepared.
comment as
to
an
hear
answer
more
if I
witnesses.
figure it out.
What questions, what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times. I
Mm.
would have to read a little bit of this to form the questions.
Under my authority, under 90611.
She's shutting it
then,
down.
And given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand when and then we'll
that's
bring
it?
the jury out, and then I will simply
He's not
ask
gonna
the
like
state
that.
if there are any questions, and then we'll move on from there.
Just so I understand what you mean by closed.
Means you don't ask
I'm
any
not
more
allowing you
questions.
to ask her any additional questions, given your full and fair opportunity. that
Oh,
you
so the
had
guy behind him is
previously
upset. See
when
that?
she was called by the state, and given
Maybe it's
the
kin to him or
opportunity you
something.
had this morning and your failure to identify for this court any probative and relevant information that she would testify
So he
to
does have a
about
supporter.
what's in that report.
How do I?
Everybody's
first of all,
got
the
somebody
report
on their
is moving
side.
In order. So I would have to essentially read at least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out, the jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for
I
then?
have
if
to do
can't-
that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary,
You're gone.
you will be removed to the other courtroom and that's.
So I'm being held in contempt again?
So I see her last nerve has
No,
been
it's not
gotten on.
contempt, sir. It's a finding under Illinois versus Allen. It's a warning that.
He should read it.
will
It's
forfeit your
actually a
rights.
much shorter case than I thought it would be. It's like 2 pages long.
Contempt finding.
I might as well have just stayed over there then if I was
Mr.
going to get held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're gonna
Just take me over
continue,
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're
a mis-
attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal? Why am I being
Mr.
held in
Brooks?
contempt?
Has he got a brother or something? Like what kind of ties
That's
would
the-
you
that's
have to
the
have
whole-
such close
that's the
ties
whole
with Croce
reason
to
I
be a
didn't wanna
supporter
call
of
the
this
next
guy
witness, and I'm gonna
and
be
think he's
bringing
being
you over in
mistreated
any
in
event.
court?
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive outbursts.
Well, then remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I want
Obviously
you
you
in this
do.
courtroom.
Obviously you do. You brought it up before we can even get
Here
to
we
All
go.
right, Mr. Brooks has forfeited his right to be present in this courtroom
Illinois
for the
versus
remainder
Allen,
of
baby.
this witness.
That decision's getting to work out.
Even
So
though
did
it will be
did I
short,
actually forfeit that right?
you have forfeited your right to be present. That
And
is
how
the-
did I forfeit that right?
True,
Brian?
could be another
Right.
sovereign citizen
We're going off the record.
who
so that he
also
can be
hasn't
removed
read
to the other courtroom,
Illinois versus Allen
and
because they're
he
too
can
busy
call
reading
his
lawful
next
laws.
witness After we complete with
Yeah, maybe
Ms.
so.
Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back.
So he and his supporters
So
think
why
it's
am I
very
being
fair
held
for the
in
jury to
contempt now?
not
We're
hear
not
about his
holding you
prior
in
beatings
contempt.
of
What did I do?
Erica.
All right, I'm gonna step off.
But they find it's
interrupting.
terrible if she can't be nitpicked over a police report she didn't write. Yeah, I agree with this. I think it's time for that. And I think, I went back, actually, as I said, pulled this decision up and read it because I was so irritated this morning listening to this guy attack the judge and other people, including the witnesses, and make a mockery out of the trial as he's been doing and yelling stupid things in front of the jury, being as disruptive as he thinks he can get away with, not just frivolous legal sovereign idiot arguments, but being fully disruptive and insulting the judge and calling the DA a liar. And the jury wasn't in the room when he did that, but he did it. And one time the judge was trying to talk and he was yelling, "Stop it," at the judge. Yeah, I don't think so. So she's doing the right thing here. And in my view of reading the decision, she's empowered to do it. And reading the decision, I can see why she's been a little more reluctant than I would have thought she should be. But I had not read the decision before. And it basically, the point of it is that you got to give the guy every opportunity to come back into court as soon as he promises he's going to behave. So therefore, kicking him out isn't so good because as soon as he calms down again, she's going to inquire whether he can come back. And so just be back and forth. So she's trying to keep him in there as much as she can. And that's also his constitutional right as long as he's not abusing it. So here we go. He's back out of the courtroom because he's not going to behave. Doesn't think he has to behave. And I agree with this. He hates women who disagree with him. And, I didn't know why he went through this parade like he did, and I still don't know the answer to that. But what is clear about this guy in terms of motives, or he does hate women. I think he hates men too, but men he doesn't like. But he particularly seems to have disdain for women and sees them as beneath him. He cannot stand answering to this judge at all. And he really wanted to humiliate and abuse Erica, I think. Yeah, I think his lack of respect is general. That's for sure. But if you did watch his interrogation with Detective Carpenter, you will saw him try and have a bro moment with the detectives talking about Erica, being a liar, and it's just something we all got to deal with. You know how they are. Why can't we put them in jail for accusing us of this stuff? You know what I'm saying? That's kind of how he played that when he was trying to figure out whether he was actually being investigated for the parade murders that he did, and he was being talked to about assaulting Erica. His main thing was what a liar she was and how terrible it was and what he has to go through, what she was putting him through, and made up the story about the imaginary friends that he'd come to town to see and watch a game with, and how Erica had misbehaved and was holding his money from him, and it's just a bunch of lies, which that's all he does. So why did he do what he did that day? I think it looks to me now he was just in a rage from his prior fight, drove into the parade route, didn't give a crap about anybody in his way, beat the horn. You're not getting out of my way. You get what you get. And then when he got out of there, he abandons the truck and tries to change his flip script again and act all calm and that sort of thing. So again, while we're on this little break, people have talked about insanity, and insanity under the law is not insanity under normal thinking. It is, for example, you can't understand the difference between right and wrong, or you can't control your behavior because of the mental defect you have. The fact that that he ran from the scene and was immediately lying about it after that, tried to change his clothes and things like that, argues that while he may be crazy, because mass murderers are often crazy, serial killers are crazy, the insane definition for the legal purposes is quite different. And to me, his behavior indicated obviously a notion of a difference between right and wrong, or he wouldn't have thought about changing his clothes and trying to flee the scene. He knew the police would come after him, which means he knew what he was doing was wrong. So I don't know that he could have mounted any kind of reasonable insanity defense at all in the first place, not under the legal definition. I mean, serial killers are often crazy, like Dahmer or Ted Bundy or whatever. That's crazy. What they're doing is inherently crazy. And if that were the standard to get off for insanity, then they all would just get off. So it's not. The definition is different. That's at the time of the crime. Whether you're competent to stand trial is a different inquiry and a whole different test, a whole different definition than the legal insanity defense. The competency is different. Whether you're competent to stand trial and represent yourself is a little bit added on to the just competence thing. So these are three different things. I talked about that in a boring video before. And I wouldn't be so boring about it right now if we weren't on a break, but it does come up that people think, well, he's trying for insanity. He's not trying for insanity here because he's not mounting an insanity defense. Now, he could theoretically be trying to say that I was allowed to represent myself when I wasn't competent to do it. And that could be the case, but he should approach this differently if that were his actual motive, because he does demonstrate some competence in being able to question witnesses. He has organized files, talks about legal principles and things like that. So he doesn't have to be good at it. That's not the test, is whether he's good at it, effective, or anything else. It's, does he know what's going on, and he's participating in it, and that's kind of what that is. Now, I didn't see him as respectful with the temp worker. I think he hated that guy. What I interpreted from this at the end of the testimony yesterday was when he was laughing and trying to giggling and stuff, that he was trying to giggle at this guy because the guy had actually stood up to him on behalf of Erica. Really don't know why he called that guy to the stand other than trying to diminish him in some way, because that guy was actually pretty awesome. Yeah. The thing about insanity, and I'll just talk about North Carolina. So if you are not guilty by reason of insanity and you're committed a violent act, you're going to an institution and you're going to stay there until you're deemed cured and not a danger to yourself or others, are unlikely to repeat the same acts that you did before. That has fortunately not been an easy burden for these people, the few people that do it, to meet. Maybe they think they can, but they haven't. So, whether they really would repeat or not, I don't know, but they haven't been too successful in getting out on that very quickly. And I did have the experience a long time ago of going into a nut farm to, I shouldn't call it that, an institution to spend time with a mass murderer, talking about something for quite a while. And I would say those conditions aren't so great at all. and pretty intimidating, actually, the whole situation. Not anywhere that I would want to be. I say that for sure. I don't know that it's as bad as Central Prison, though. I used to live next to that here in Raleigh, and that seemed like a place that you'd want to avoid as well. I think for the part of the case that I watched, good enough on intent. I mean, what can you really do there? He's not going to admit he did it intentionally, so you're looking at circumstantial stuff to a large degree, I guess. You know, there's no evidence that the vehicle was malfunctioning. He said he beeped the horn, so that's an intentional act. There's no indication that the vehicle was operating on its own. And hypothetically, you could say, well, you accidentally came onto the parade route, but everything you did after that was intentional, or maybe you accidentally hit the first person. But, you know, he hit so many people and went so
You
long,
are
I just don't
unmuted,
think
sir.
intent can really be
The jury is on
a
its
bad
way
thing.
in.
I see
Well,
we're
we'll
getting
be shortly.
spammed out here by a very exciting
I'm going to mute you if you do that, sir.
chat.
I'm not gonna do it with the
Yeah,
jury.
I blocked
That's
it.
why I asked now before the jury came in.
Oh,
I
God.
addressed that in my opening type remarks and record.
So the
when we
judge
came
wanted
back
him
on
to
the
finish
record
by today, which I
already
think is
addressed that.
pressing him too much. Even
So
though I
would
hate
it be
this guy,
proven for the
I still
record?
think that. I don't think it's going to happen either. But maybe they'll finish
Will I at
Monday.
least be told why I'm held in contempt.
They got to
when I
do
didn't that?
closing arguments.
Civil or criminal?
You know,
It's a
just guessing
misstatement
by
of what I did,
Wednesday
sir.
or something like that, which is pretty quick.
So why am I
I
over
will
here?
advise when the jury's coming in, and if you can't be quiet, you're going to be muted, sir.
No, I
You
don't.
gonna mute me anyway.
Not if you're quiet.
So I gotta be quiet like a little kid?
It's not what I said, sir. You have to be
That's what you
respectful.
said.
You have to be respectful of the proceedings.
But nobody has to be respectful to me though.
That's a mischaracterization as well.
So can I say for the record that two of your bailiffs was just making gestures behind my head and I seen them through the TV screen and made me feel uncomfortable?
Shout out to the bailiffs. Thank you, bailiffs.
Jury's coming in. Please rise for the jury.
So that's not gonna be addressed.
Mr. Brooks, I'm muting you.
Boom.
Oh, okay.
She's about tired of him.
It was later affirmed. Okay.
StreamYard just lets you stroll the comments down the side. So this is like the third or fourth time I've used this thing, but it's pretty good so far. If I can use it, shout out to StreamYard. Anybody can do it.
Instructions for a second. You should just keep them. They're nearby. Thank you, everyone. Please be seated.
He's got some Kleenex there in case he starts feeling sorry for himself again. It's not easy in today's world to be a mass murderer. It's just not. You don't get the respect you deserve. I mean, he
Just
keeps
for the
saying how
record,
much
Mr. Brooks
respect he
is adjourned
deserves.
from another courtroom. That
It's
should
awful.
not affect your deliberation or verdicts in any way. At this time, does the state have
boy, I wish
any
I could hack that
questions
puppy.
for this witness? Right. Thank you, ma'am. You may step down. Thank you for being here.
But wear the battery out on that shock button.
All right. The defense may call its next witness, please.
You have to hook him up to a Tesla charger and keep him topped off. If I were the bailiff, oh, I'm sorry, Your Honor, I bumped into the wall again for an hour. Sorry about that. For the record, I accidentally shocked him for an hour.
Go ahead, sir. You can call your next witness.
I thought I was muted.
You're not muted.
Audio specialist Darrell Brooks preparing to
How
call
long
his
am I
next
supposed to
witness.
stay here now?
I'm going to excuse the jury. We'll hopefully have you back shortly. All rise for the jury, please.
So we had this case just a couple of weeks ago where the dude had kidnapped either his wife or his ex-wife or whatever and had assaulted her and things like that, and he got to question her on the stand. I watched a little bit of that case, and he was very calm in all of it, and it basically was like, you know, the jury's going to do what they're going to do, and I appreciate the opportunity to defend myself. Like, he wasn't ultra bonkers like this guy. And it makes me think that guy had something in his brain that just flipped off partially. And so he does, you know, he did the criminal acts he did, but of course he was found guilty, but he didn't act like this bozo.
All right, the jury is no longer in the courtroom.
It should just have a curtain that comes down in front of the jury and it can lift back up again.
Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either
Complain
ask
about-
to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness?
Do you just go home in contempt again? Like she hasn't answered that 1,000 times.
You're not muted. You're unmuted.
So what's going on now? Now
Oh,
am I being
God.
contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a
Look how
defendant
certain he
who
is
stubbornly defiant,
that he
disruptive,
knows what
and
he's talking about.
contemptuous. That is not the only way in
And
which
being
a
arrogant
judge can
And so stupid and
address
wrong. He's like a distillation of a lot of social
defendant
media.
that is being
He knows how to throw
discourteous,
words out. He knows how to
disrespectful,
be arrogant and
disruptive.
insulting. He doesn't know
So
how to
pursuant the
understand
authority
or
in
listen.
Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd.
He's got a judge doing more
366.
research on this crap.
The Colorado Court of Appeals from 2007, and then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd, 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom?
So somebody went to the trouble of finding all these cases
Calling of witnesses.
for
and your
her
next
or her
witness.
herself. Nice.
I thought you was using Illinois versus Allen.
You
You
can
are
use more
welcome
than
to
one
come back
case,
into this
idiot.
courtroom, sir.
See how you got 3
why
boxes
was I
there?
removed
You
in
can
the
use
first
more than
place?
one case because you're
I've
an
made my
idiot.
findings, the record will stand. I will ask you one
no.
last time.
Count some more.
Would you like to come back into this
hit the big
courtroom
times,
as
I
you
got
call your
spam.
next witness?
You're not finna hold me in
Blocking that
contempt no
one.
more. Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time
absolutely
and he fails
true.
to answer it with a
He
yes or
pretends like he
no,
doesn't understand the
I
question,
will
or as she
take
says,
that
just goes
as
down a different
no
rabbit
that
hole. It's
wants
all
to
he
stay in
does.
that
You
courtroom.
can't answer
Mr.
for me.
Brooks?
You can't do that. You can't do that.
Mr. Brooks,
She
I'm
can do it.
advising you that I will,
It's a lawful law. I
he's
checked.
interrupting me once again from
Okay,
the
you
other
talking.
courtroom.
You the one talking right now, so don't do that.
That's
I'm going
because
to
she's
mute
the
him
judge.
Because he's not being respectful, and he's just spouting off. So, he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings.
Nice.
I will give him one more opportunity
Oh, man.
so that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your
No.
next witness?
Don't try to seem like you trying to honor my rights now because you haven't been
Okay,
doing
he
it before.
is, again, not
Don't-
answering the
don't-
question
don't try
directly.
to put on no. Don't.
I'm going to mute him again. As I've noted before, this is a clear method now that Mr. Brooks is employing, that when I've done something that he disagrees with, that he just continues to argue with me.
Exactly.
and does not answer questions directly. So based upon
So this would be a big
continued
problem as
disruptive
his
behavior,
witnesses
the fact
are
that he
in the
will not
courtroom,
answer my
or not in the
questions
courtroom, but they're
directly,
there to be
I'll find that he is
called.
continuing to forfeit his right to be present.
I
in
don't
this
imagine
courtroom.
he'll move to
Clearly,
his
the audio and
examinations
visual
without yapping
technology are
about
working. He's
the
been
nonsense he's
responding,
talking about. So
although
how
not
do you
appropriately.
move on with that?
He is in that other courtroom. We can see him. He does have the headphones on, and I confirmed that he can see and hear as well, based upon the
And is
court
she going to close
personnel that
examinations
are in
as he
the
continues to
other
argue?
courtroom. So
She
I'm
may
making
have to do
another
that.
finding
Of course, every
that
witness he's
his
called so far has been great for the
appearance
state.
from the other courtroom is the functional equivalent of him being present in
Boom.
this courtroom.
Totally agree.
Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call
Are
your
you
next
asking me?
witness.
Are you telling me?
And if I don't get a direct response out of you, I may
Then I'm-
ask it again.
and then I'm
if
gonna
you
let
fail
that
to
witness
give me a direct
fly.
response, then you will forfeit your right to call any other witnesses. So I'm going to unmute you.
You can't do that.
Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which witness you intend to call, so we can at least have that person
It's not gonna
ready to
happen.
go and outside the courtroom.
Sometimes you see the optimism leave her
Who will
body,
be your next witness?
but
I'm
not
calling
now.
no witness if I gotta be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've
I
made
gotta
a record
answer
of that,
everything.
sir.
I have to answer everything though. Everything you ask me,
Yeah,
you expect me to answer.
she's
but
the
then
judge.
when I ask you questions, you never have to
Right,
answer
because
anything.
she's the judge.
I just
See the
put
black
on the
robe,
record that two of your
the
bailiffs
bench.
just made gestures. When I'm looking at them off the reflection of the screen, they're
Mm-hmm.
making gestures behind my head that make me feel uncomfortable. I just brought that
But
up.
who
on the record.
cares
You
though?
didn't even address
See, we
that.
don't care, see.
Mr. Brooks, I didn't address it because frankly, you keep interrupting me, and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that, and if appropriate, he can bring that conduct to my
They need to get
attention.
Captain Dassault
I'd
away
also
and get
remind
Captain
the defendant
Assault
that at any time you
on
can
this
also
case.
ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like
These
to
are
come
some
back
basic
over to this
lessons he didn't
courtroom?
learn. There's Wisconsin, they call a truck a
That's
car.
not answering my question, sir.
One of life's mysteries.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not a delay
Brooks,
and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by
Is it?
definition a
Yes.
judicial determination. It is on the record.
Judge, are you making a
If there is
judgment?
a conviction, you can raise whatever issues you want on appeal if you are convicted. But
She cannot
you don't
wait
need to
till it's
have
their
this back
problem and not
forth
hers.
Every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an
It would
objection.
be just like that meme with the
or for a
guy trying to
question
decide
that's
which
being
button to
asked,
press and he's
or for
sweating.
a whole host of other
Except they would
things.
both say shock,
But right
and I
now,
would
you're
just
not doing anything
go ahead and press both. I wouldn't be
legally
sweating.
relevant.
I would
You're
be
being
just pressing the button.
disruptive. I would like you to be present.
It would be cool
is
in
always
cases though if whenever you made
what
an
I
objection
want
and it's overruled,
during
you
this
received a
case,
small electric
certainly I
shock.
think, is
That would help move all
important,
cases
but
along,
you can
I think.
forfeit your right to be present.
And
by
if
your
it's sustained, the
conduct,
other
which you
attorney
have done
receives a small
repeatedly
electrical
throughout
shock.
this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off. so
Of
I
course,
would-
yeah. So
Mr.
remember,
Brooks, I'm advising you that if you fail to call a witness, you will
Other-
forfeit your
other
right
witnesses
to
he
present any
he has called have been
additional
victims.
witnesses.
so there are likely more
I'm
victims
doing this outside the
sitting
presence of
in
the
the
jury
courthouse
right now
waiting
for
for
a
him under
reason. I
subpoena
need to know from
while
you
he
right
wastes their
now,
time
you are
because he does
unmuted.
not care about
Who is your
victims.
next witness?
She trying to say something to me? Yeah.
Now he's going to put the headphones on. Check the
What you
volume.
trying to say?
That was very disrespectful, sir. You chose to take off your headphones?
Man, I'm getting
Yeah,
spammed
choose
out
to
with
I'm
that.
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay,
Yeah, just hit that one.
Why should I need to hear what
So
you
let
saying?
me be clear, sir. And you are
Interesting
not,
how they choose who to spam. He
I
don't
will
have
ask
to do
you one
nothing.
last time, sir.
He's reading
Who
that
is your
Bible
next
again.
witness?
First of all, is she talking to me again?
He, this,
We gotta keep doing this little childish stuff, dude. I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
Right. Nobody else has any rules they have to
the
follow.
record should
Judicial
reflect
misconduct.
At
that
its
Mr. Brooks
finest.
is
I like when you
spouting
said that.
off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to
Remember, he was a big
answer
crybaby
simple
yesterday.
questions. Mr.
Big
Brooks,
crybaby in his opening statement.
you
That's
are,
not my name. I told you I don't consent to being called that name.
Nobody cares.
sir, you are hereby advised, this is the last time I will ask this question.
And then she's going to let this whole
or you
tranche
will
of witnesses
forfeit your
go, I
right
bet.
to present
Can't do that.
any
Show me
additional
show me
witnesses.
Show me that lawful law.
Because you are not cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks,
That's
how can
all
I
he's asking.
forfeit not being able to have a defense? Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will gladly bring you back into this courtroom so you can present your additional witnesses.
This is
But
so
you need
insane.
to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day.
She just
It's
needs to
not
do
my
what he
intention
wants.
to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding.
Yeah, he's trying
So if
to
I don't understand something,
create his
I'm going to
appeal
ask a
issue.
question. I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If I'm intentionally
stupid.
trying to be disruptive. Because that's not the case. And I feel very disrespected.
Yeah, it
every
wasn't there
time the
before. I
record
think it
is
must be
made.
the courtroom, maybe
Making it
having two
seem
mics
like
on and
that's
stuff
what's
because this guy
happening.
keeps jacking around with his headphones on and off or something like
So
that.
of course it's gonna frustrate. Of course it's gonna make me a little bit upset. And I just want you to understand that. It
God.
seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. It's not up for debate. You control what's going on in there. That's not a dispute.
Right. He hasn't disputed that. Uh-huh.
But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting.
But who cares, though?
Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged.
I wish he were.
One of them is held in contempt.
It also
What's the
says,
third, Mr.
because I read it,
What's the third?
the third is kick your
The
butt
third
out of the
is
courtroom.
Remove from the courtroom while the trial continues, right?
Yeah,
That's the
exactly.
third, right?
It also
That's
says
what's been done.
contempt is not useful if the person
So
won't
now-
respect it or is using it
Where
for
does it
delay.
say after that having me on a headset or being able to see and hear
It's
and all
even
this,
better.
how is that not prejudicing my defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal. You
This
can
is
raise
why I
that
say that.
issue on appeal
This
if you are
This is why I say
convicted.
that.
The decision says there are at least 3 ways for the trial judge to handle this situation. It doesn't say there's only
In the
3.
prosecution,
So the third is he's removed until he will behave. But it says at
understand
least
that, sir.
3. And of course, technology just
Fully
marched
aware of
on
that.
and he's able to participate as he is here while he's out of the
I'm
courtroom.
not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
If you'll behave.
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law.
Not back to the what did I do stuff.
I will ask you again, would you like to come back into this courtroom?
Are you gonna kick me out? Are you gonna kick me out?
Sir,
Depends.
I'm asking the questions right now. Would you like to come back into this
Yeah,
courtroom?
exactly. I mean, he's
Yes or
just
no?
playing games.
Are you gonna kick me out? Are you gonna kick me
Sir, it's a yes or no question. Would you like to come
Well,
back
my
into
answer,
this?
my answer was based on the reason why I'm answering like that is because the moment I say something, it's gonna get me put out. I don't want to keep hauling this stuff back and forth and back and
Oh,
forth.
yeah,
and
it's a
back
lot
and
of
forth
trouble
and back
for
and
him.
forth.
A lot of trouble.
It makes essentially it wastes his time, really.
Then stay over there. Then
I'm
say,
well
I don't
aware
want to
of
come
this.
back.
That it delays the
Yeah, but-
proceedings.
But then it's laid at my feet as if that's my attempt. You think I want to be over here?
Yes.
Sir, I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just
Now remember, his
everybody.
thought is for killing 6 people and injuring
Then I
scores
suggest
more,
that you
he should
conform
receive
your
no punishment. The
conduct
case
to
should be dismissed. He is
requirements
asked over and
of
over for the
courtesy
case
and
to be
decorum So
dismissed.
that you don't run the risk of forfeiting your right to be present. But that falls on you and you alone, sir.
There is no conduct. I don't understand what you mean by that. I really don't.
Mr. Brooks, you
He's
may
such
not
a liar.
understand it. I don't think that's accurate. I think you know exactly what you're doing.
Yep.
If that's what you think, that's fine. I can't
And
argue with
you have
about yours.
demonstrated throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses.
I think he said in his interrogation
So
when he was picked
you
up for
clearly read, write,
beating
and
Erica
understand
that he was.
English. That's not an issue here,
He
sir.
said his education was 12th
Are
grade.
you
I think he said.
self-represented? Absolutely. Does that present difficulties and disadvantages?
Yes.
Absolutely. But that takes me back to when you waived your right to counsel.
Mm-hmm.
You
Knowingly.
did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so.
Yeah, because he gets to say
Meaning
subject matter
advantages of having
jurisdiction,
an
which they
attorney,
would
the
never do,
disadvantages of
or ask for an
doing
oath
it
or
on your
stupid
own,
stuff.
and you made a deliberate decision
Because they would
to
not have slowed the
represent
proceedings
yourself,
down like
and
this.
that comes at a risk to you of, yes, at times not fully understanding the law.
Mm-hmm. You
the
knew you
rules
weren't a
of
lawyer when you
evidence,
did it, you
the
idiot.
rules of procedure, but you do so at your peril.
It is
It's
fair.
not fair to state, Your Honor, because
So I'm going to do the following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over, or he doesn't. Either way, he's going to be asked to call a witness.
Okay, so
in
she's going to
front
bring
of
him
the
over.
jury.
She's going to say, call a witness.
will ask
He's
him
going to be disruptive.
3 times if he fails to give
He's
me
going
a
to
direct
yell at her
answer,
while she's
and
doing
after
it
the third
about how
time,
unfair it is.
I will make the appropriate
And then she's going to
finding,
do that.
but I will do
She's
that
gonna have to
outside
kick him
the
out,
presence of the jury.
and then she'll release the witnesses.
We are going to continue, so we'll go off the record, and he will come back over here. Thank you. We are in recess until that happens.
This could be true. And I'm not going to suggest that having a law career requires you to be some genius, because it doesn't. But I see a lot of flaws in his logic that would lead him to be unsuccessful in arguments where you have to have a train of thought that other people can go along with. He seems to be missing that. You know, this rabbit hole stuff that he does. He did in his interrogation of when he's asked a question, he just switches off to somewhere else. I don't know that works anywhere. It only works here because, in my opinion, because he's a defendant, and under the Sixth Amendment, you have to entertain this nonsense. Now, you know, maybe his brain could have been reformed to be able to do that. But I call him an idiot. He's not, but so stupid, right? He's able to game the system as successfully as he has. but I'm not impressed with his reasoning capability. In addition to the fact, of course, that he does see killing these people as something he should pay no price for, and beating women as something that they deserve is another thing he seems to think. I mean, I think that's the thing here is, whatever intelligence he has, and then however it could have been developed if he'd wanted to do that, he definitely thinks that he knows more than he knows, and he thinks he's more clever than he is. And that's dangerous. Your inability to assess the situation accurately can get you in a problem, whether it's a fight or whether it's an intellectual contest like that. He's not appreciating what is happening around him from the standpoint of, he thinks because he's been able to control people and women and other people before by beating them and tricking them and wearing them down, that should work here. And of course, it's ultimately probably going to be very unsuccessful, but it seems to me that is what he's trying to do, and his little show of this is stupid. I would agree with this, except I did see something I didn't check this morning, which was that they said he'd represented himself before in some other cases, because I think he's been in more criminal trials than I have. I'm not a criminal defense attorney or anything anyway, but I think he's had some courtroom experience. It strikes me. And again, you see lesser cases like him on social media where somebody will say something with complete confidence and arrogance that they allege as a fact, and you show them something that says, well, hey, actually, with all respect, it's actually this other thing. And then they will simply just tell you you're stupid and you're wrong and all that. And they won't bother to look anything up. And he's, to me, a little bit like that. He's latched onto some sovereign citizen nonsense. He glanced at the Illinois versus Allen case. He hasn't looked too much into it. And that's the extent of what he knows. When he says, I don't understand the nature of the proceedings that I'm in, is his attempt to preserve a competence defense later on. And defense is really the wrong word, but a ground for appeal to say I wasn't competent to represent myself. So he cites those words out of cases. The judge has been making a record from the very beginning when she was applauding him for his cross-examination and some of the arguments he made. Sometimes when she sustains his objections and says things like that, it's a demonstration that he does understand, what he's on trial for. He does understand how this is working. You ask these questions, you make these kind of objections. He's made lots of objections. He's using the right words. So he's undermined his own theory there of incompetence, if that's what he wants to sustain for appeal, by the overall performance he has. Because again, the standard isn't, well, are you good at defending yourself? It's just you're basically able to know what's going on around you, not that you're some kind of scholar and that you've had time to study and learn all the law. As she said, he was apprised of those risks when he decided to fire his attorneys, and he decided to do it. And so here's the result of that, right? So a lot of people say that, well, I could beat 50 lawyers up against me. You hear that all the time when you're a lawyer, the stories of the famed pro se litigants that are so clever. And there are some people like that. But for most people, is if you really think that, it's simply because you don't understand the extent of the things that you don't know. So you just imagine how easy it is, and maybe you watched a TV show. I mean, take a totally different topic, plumbing in your house. You might think, well, how hard is it to run a pipe? That's stupid. You don't have to be smart to do that. There are a lot of ways to mess that up. But you want to build your own house, there are a lot of considerations that if you think it's just putting nails into wood, you don't understand anything about what it takes to do those things. So it was a QC site in South Carolina one time at a nuclear facility, and they had a sign up that said, anything's easy if you don't know what you're talking about. And that's true. So, of course it's easy because I don't understand how hard it is. So it must be easy. And I think, he decided he could hit the easy button and make these arguments just as good as these lawyers could. But remember, when he fired his lawyers, they wouldn't make a lot of these arguments that he's making. They wouldn't do that because it's stupid. But they would have probably arranged some kind of theory of at least lack of intent. And I don't know that they could succeed on lack of identity. How can you really do that? So if all you're going to do is struggle with intent, you've got all these other charges, reckless, et cetera, and all that would put him in jail forever anyway. So kind of what's the point? But, you'd have to have some kind of argument that, well, he was trying to evade people. He was actually trying to minimize the destruction, and that's what they would have done. And you would have looked at him, or I would have looked at him and thought negative things about defense attorneys, even though I understand what they do and like a lot of them. Sometimes the theories they come up with just make me grimace, but it's the job that they have to do, and that's what they would have done. I don't think he's going to do that here. I'm not sure what he's going to do, but what he wanted to do was be disruptive. He wanted to make ridiculous arguments. He wanted to be able to attack witnesses, and his arrogance of being around, I guess, people that he can intimidate and bully, maybe his mother, certainly his girlfriends and other people like that. He thought that he could extend that into this trial. He successfully evaded other cases before. He was, when he was arrested, he jumped bail on 2 different charges. So he may have run into one here bigger than he can bite off. I hope so. I hope that we get the right verdict here. I think we will. So I think, if you saw the other day when they had the COVID exposure and the judge called the jurors in and she queried them on the record about whether they had any concerns about continuing in the case, that was on the stream, obviously not showing the jurors, but you could hear them. And they all, to me, every single one of them answered with a strong voice that they would continue. They had no concerns, is what they answered back to her. And that, to me, indicates, people that are paying attention, that they want to do their duty. And in a case where the evidence is so clear like this, I think the result will be one that you can probably count on within the guidelines, that there's always some uncertainty in a case. But I don't think there's any doubt here of what's going to happen. Even he said, I won't contest any facts. He said that in his crying opening statement. And if he were capable of embarrassment, that opening statement should cause him to feel embarrassed, because that was hilarious. That was hilarious. That's what you kind of maybe see from a guy who his strength is in beating women who are much smaller than him, getting into his mom's SUV, that he used his mom's SUV in his rap video, and running over innocent women and children. That's how this guy operates. So that's his power and strength. And then yelling and demanding respect. The other day, he told the judge, I'm a grown man. I got grown children. So his main accomplishment was getting somebody pregnant, and the person lived long enough to grow up. And so he deserves respect for that. And I just don't think that's the case. I don't think he is somebody who deserves respect. And so the judge has to behave the way she's behaving, at least in terms of not trading insults with him. She can't do that. I've heard them do that before, but in this case, she can't. And so she just has to take some of that, at least. But I think she's closer to her limit than she was. And that's difficult, because he's trying to mount his defense and call his witnesses. He's on the verge of losing that. And I'm sure that's a concern for her, that he'll have an appeal and say, well, I wasn't able to call witnesses. That's why she keeps asking him, call your next witness, call your next witness, call your next witness, call your next witness. Because if you refuse to do it and the witnesses are in the courtroom, then that's your choice, and you let them go and to get to the end of this thing. And I don't know. I mean, obviously, if you watch this case, every witness he calls confirms that he's a sleazeball, murdering loser who's completely guilty of everything he's charged with. And I think we all know probably many crimes he was never caught for. And I don't think he was caught for everything he's ever done to anybody, of course. So he's helping the state's case when he calls witnesses, but I think the case is strong enough all by itself. Sorry to blab on. We are in this break, which is taking quite a while. And remember, he was going to come back in. She was going to ask him to call a witness and then see what happens. And it's quite possible that there's a disruption occurring right now that they're not showing based on that going on. Yeah, court's been in recess more than it's been in session today. It really has broken down. So I turned it on in the background when I was doing other things this morning, and based on how he was behaving right off the bat, I was like, yeah, it's worked up today. This is going to suck. And I thought, well, what he will want to do is abuse Erica when she's on the stand, and he did want to do that, and he was able to do it some, but it didn't work out for him all the way. So it was bad enough that they called court off in the middle of what was going on for an early lunch. I didn't like it yesterday, even when he was in control, because I didn't like how he was treating the witnesses who were on the stand, including the labor guy, the first guy. When the guy would give an expansive answer, he would make mocking expressions at the guy and then tell the judge, we got to strike that judge, like they're teaming up on how dumb this guy is. When the guy on the stand was the one guy who was willing to stand up and try and help Erica and keep her from being subject to this guy's violence. So he didn't deserve the treatment he got from this idiot. And I'm glad he's off the stand and back and doing whatever he needs to do. Yeah, your mom's SUV and your hip hop video, not so awesome, I imagine. One of these days, his kids will see these YouTube vids of his trial, and that's true. But some of them are kind of older anyway, and you got to think they've seen things you aren't going to see in this trial between the parents and how he is and all that. I mean, I hope the best for them. And I don't know that what they're seeing in terms of his behavior in this trial is nearly the worst of what they've seen of this guy. Who knows, right? I mean, he's not a good actor. So what kind of law do I practice? So I was a litigation attorney, and primarily civil litigation and a lot of commercial litigation, patent litigation, and things like that. I also represented municipalities. So I represented the police and did police brutality cases and some things like that. And basically, just if it's any kind of litigation, I was in it. And before that, I had some experience on some of the law enforcement side in North Carolina with tracking down criminals and things like that and other stuff. So, but years ago, I became general counsel inside of a larger construction company and traveled around doing things like that. It was pretty fun. So not in court nearly as much as I was in early practice. And right now, I'm mostly taking it easy, just a few cases until I start another endeavor. Yeah, calling your mom. You've taken your mom's SUV that you used in your hip hop video that was supposed to show how successful you were. Then you took it and you murdered a bunch of people with it and ruined it. And then you call your mom, say, Mom, please call me an Uber. Please call me an Uber. I agree. Not the most manly,
present in the courtroom in person
manly moment ever.
and in custody wearing a suit.
I feel like his
and tie.
music video wasn't
Actually,
really an
his
accurate
coat is
representation
off,
of
but he's
his
still
life.
wearing a mask. And the jury will be brought
Yeah, this
out.
guy's
and
Amber
we'll
Heard's
be asked to
nothing
call
compared
your
to this
next
guy.
witness.
All right.
You can call it that name.
Yeah,
noted.
we got it.
And
I got a name
still
I'd
need
like to call you.
address subject matter jurisdiction.
No, we don't.
Before the jury's brought out,
I will not be doing that.
will it be proven for the record?
The record stands.
The odds of this going off the rail? Anybody got less than
Is that a tacit
100%?
agreement?
Tacit
So,
agreement.
answer that question, Your Honor.
Anybody still playing bingo? There you go.
I make no such agreements with you, sir.
Thank you.
So that means you can answer the question then. Will we be addressing subject matter jurisdiction
It's just
on
such
the
an
record?
idiot.
And will it be verified and proven?
Tacit agreement.
Non-responsive answer is a tacit agreement, Your Honor.
No, it's
Jury's
not.
coming out.
That's done. It's tacit agreement, and that is not the definition of it. Well, I don't know. Maybe I just don't know what a tacit agreement is. That's possible too. But at any rate, I was never a criminal defense attorney. Only criminal defense stuff I did was just for people I knew or involved in helping clients who we normally would represent if they found themselves
Thank you, everyone. Please be seated.
having a negative interaction with the law. But if it was bad, we would associate with somebody who knows how to do these cases the right way. Good relationship with the DAs, judges, know what they do, all that.
The defense may call its next witness.
Who's here?
Maybe he will call one.
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Who decided that?
What was the last two?
Aldrich and Lescano.
Suddenly he does have an understanding of all the procedures and everything that's going on again.
Let's go with
Deanna Aldridge.
Wow.
Deanna Aldridge?
Glad nobody bet me.
All right, very well.
Slide the Bible over there. Take a little break from reading the Bible. It's right in the middle of it, too. It's pretty exciting. Hate that he has to stop at this point. I hope nobody spoils it for him. COVID threat is over. So I wonder if this next witness will be another person who hates him and he almost killed. Maybe he's reading the story of Job and he's imagining the judge as Job and like, how many things can I put her through? So I don't see Galileo in the courtroom today, that photographer with the telescope. I guess they got all the shots they need. Made it an early week.
I'm sorry, I think she was in the other building, so.
It's all right. Thank you for letting us know.
He gets all these papers together and then he asks them how they're doing and then he's like, what do you know? And they're like, I know you ran over all these people and murdered everybody. Okay, no further questions. So the judge had hoped to finish today. That's not happening. Can't even believe she said that yesterday. And again, I thought if there was something that you were doing that would prejudice his defense, it would be pressuring him to finish his whole defense in a day and a half, even if he weren't a nutbag, ridiculous person like he is. That's asking a lot for the kind of case this is. I don't blame her for wanting this finished by the weekend, but it wasn't going to happen. But again, I'd say, Wednesday? The jury may have the case, possibly Tuesday. I don't know what kind of argument there'll be over jury instructions or that sort of thing, but once that's done, we'll get the closing arguments, which would say that would be interesting, but he may just cry again and say, look at the other side of the coin. Who knows what he'll say. And then the jury decides. I mean, if you're the DA, it's interesting how you'll do your closing because you also now have to incorporate all the defense witnesses who are supporting your case. You can't ignore the fantastic testimony of the people that Brooks has called as his witnesses that absolutely make the state's
Good
case.
afternoon, Ms. Aldrich. If you would please make your way to the witness stand. It is up by me. It's up a riser. When you get all the way to the witness stand, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left and will be across from you, will swear you in.
COVID threat is over.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
She's bringing her own water to the stand. Yeah, he was clearly put out at the delay.
To state your first and last names for the record, and then spell each.
Okay, I'll spell each. E-A-C-H.
D-E-A-N-N-A. Last name is A-L-D-R-I-C-H.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldridge.
She looks like she doesn't want to be there. Remember, he said he's going to put his mom on the
Direct
witness
your
list now.
attention- Well, first of all, let me back up a little bit.
He's backing up a little bit.
What do you currently do for a living?
I'm retired.
I'm just tired.
Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes, that's when you murdered everyone.
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
I don't think so. I will say
Do you
that.
recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Okay.
Back up a little bit to the thumping noise.
She was close to releasing
Can you
these witnesses,
describe
but
that
yeah,
thumping
you do
noise?
have to
Would
be
it just
careful
be
with that.
A thumping, did it sound like
More than in a civil case.
crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay.
Seems a little quieter to me now.
And you stated you looked out your patio and saw a red SUV.
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
He just laughed about that, by the way.
Do you recall if the red SUV was still running at the time that you observed it?
Yes.
And at some point, did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
I feel that.
What do you recall?
As far as
Description
what?
wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and
White or
dark
purple?
pants.
Those are close.
Do you recall a height?
I
That's
think
tough.
he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
That's fair.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down, yes.
Okay.
So she sees the truck.
And
She can't tell who it is because she doesn't have glasses
The
on.
individual
so-
you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though.
I think he did realize he had pushed the judge to the very edge of how far he could go without forfeiting his
Did you at
witnesses,
any
but she
time
doesn't want to do
observe this
that,
individual jump over the hood?
if at all possible.
I was running in and out of my house, so I did not see, because I was trying to find my glasses as I was running in and out.
She did close questioning on Erica
So is it
Patterson,
fair to
though.
say you were
Shut that
trying
off.
to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I do not recall.
She's nervous, but she's doing fine. His supporter is not there anymore.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
That's a good and fair answer. Sometimes people just struggle to make an answer, and I don't recall it's fine if you don't. So that's good.
Had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were gonna walk up to the vehicle, but they did not, because I yelled to them and said, don't touch it.
Good job.
So that kind of would be fair to say that kind of startled them and stopped them in their tracks.
Yeah,
Do you recall how many people there were?
maybe 10.
Good advice. Of course, she's nervous. She knows it's a televised trial. It's bad enough if it's just court. This is televised, and you're going to be questioned by a murdering nut.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
No disrespect, but her testimony so far is
Do you know if
completely
they-
pointless. Like, why did he call her?
Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
She just looked at the camera. Feel sorry for this poor lady. Wow. Look how nervous she is. I hate that for her. She's coming to tell the truth. Something he doesn't know about and doesn't understand at all.
If you
Just
recall,
hang in
did
there. You won't be there long.
Did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
I doubt it because it doesn't appear they've been talked to in any
the
way.
street that you observed the individual running.
Of course, they may
toward,
have
do you
seen it.
recall
I don't know.
What street that would have been based on the direction?
Arlington Avenue.
Good point here. Maybe some of them, although these people are all terrible for him.
Directly in front of that building.
And he was, he really wanted to get 13 witnesses, one of them being the state of Wisconsin. So he at least participated to some degree in this. I don't know, though, if he had some working order from his previous counsel or not.
You didn't
Good question.
See the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been, which street did you say?
Arlington.
Arlington. I apologize.
The guy who'd appeared before said he got the subpoena. He didn't really, I think, even pay attention to as to who it was from. He just called into the clerk's office to see what else do I need to know. And then he came. So, yeah, she can't identify him because of the glasses issue. I don't know. I'm not sure. Since she's not saying it's anyone else, what does that do?
There was a parade going on that evening?
Yes.
Did you attend?
No.
She wants to get out of there. I don't blame her. Can't be much else to ask her.
After you spoke with the law enforcement officers that evening, Did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Yeah, if they needed help, I would be down for whatever method they wanted to use.
Do you recall the name of the officer that interviewed you?
No.
See, he asked these questions like he's going somewhere, but on the other witnesses, he hasn't gone anywhere that's helped his case at all. Just hang in there. There you go. Just breathe. Totally pointless.
No further questions.
That was totally pointless. You didn't even ask her if she saw the state of Wisconsin in the room with your glasses on. That's it for her. Nice. I gotta check that Bible though and see if it's got anything new in it.
Defense may call next witness.
Seems to me their volume has gone down. See if I can punch that up a little.
One second, Your
I'm
Honor.
blowing this up. She did great. She came. She said the truth. And got out of there. But remember, he wanted 13 witnesses, so you can't help but think this
Defense
is
calls
filler.
Christopher Bertram.
All right, thank you. I presume the state heard that and was assisting. Thank you.
Your Honor, my assistant.
I didn't want to assume, so thank you for
Yes.
verifying that.
So, we still don't know what his
Looks like this one's the last
theory
one.
is, since he didn't give it in his opening statement, other than saying
Right,
there'll
good
be many
afternoon,
factors,
Mr.
other side of
Darrell.
the
Please
coin,
make your way to the
blah, blah,
witness
blah,
stand, which is
and didn't present any
to my
actual
right, it is
theory other
one
than you'll
riser.
learn it wasn't
When you get
intentional.
there,
No witness has
please remain
supported that.
standing, raise your right hand.
No witness.
Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Have a seat, please. First thing I will ask you to do is to state your first and last names for the record.
My first name is Christopher, and my last name is Bertram.
Could you spell those, please?
CHRISTOPHER.
This dude dressed up for court. Sweet.
ERTRAM.
Thank you. As long as you sit close to that table, you will not.
Now it says there's going to be an ad.
Hey, it's Adam from StreamYard. We have an exciting new
cool.
feature to announce
about StreamYard?
called Green Room, which is now
To lean in. Go ahead, sir, your witness.
Oh, I'm sorry.
Go ahead, your witness.
First of all, good afternoon. currently do for a living?
So if you can't hear it,
I do.
yeah, let me see if I can
electrical work.
pump this volume up a hair more. I did do it a minute ago. Yeah, punch here once.
Directing your attention to the evening of November 21st, 2021.
They have definitely reduced it.
Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my mother's car to our
I
mechanic
can
shop.
be quieter if you guys are turning this up to hear
Were
better.
you
I don't
aware
wanna
of
blast you
the
out.
parade going on that evening?
No.
Around what time were you taking your mom's car to be inspected?
I don't recall.
Sweet.
Do you recall seeing anything that caught your attention that evening?
Yes.
Can you state what that was?
A smashed up red car.
Nice.
And do you recall where you saw that at?
I believe it is Prospect Court Street.
So this is going to be completely pointless.
And at the time you observed this smashed up car, as you say, did you see anyone driving it?
Yes.
And were you able to make a subscription?
A subscription?
Sorry. Description of who was driving it?
I believe so.
And what do you recall?
I
You?
don't recall what I said.
Nice.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
Nice. Great witness you called there.
You made reference to giving a statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone, or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I don't recall.
This guy's knocking it out of the park. Just, I don't recall. He didn't button that top button to come in here and get bully. Very smooth.
Did you observe the vehicle stop at any point in time?
No.
So it was pretty much you just saw it just kind of just rolling past.
Yes.
Did you notice if the vehicle had any tents?
Any what?
Tents, like tinted windows?
No.
Did you notice it was my mom's vehicle because I'm a loser? But maybe you saw it in my hit rap video. That was cool, wasn't it? Didn't you think I was cool in that? Driving my mom's truck?
Do you recall in your interview with law enforcement? Well, let me back up a little bit. Was your interview with law enforcement the same evening that you saw this vehicle, or sometime after?
The same evening.
Again, he does this like he's headed
Do you
somewhere.
recall stating during
Like the last witness, he
the
headed
interview
nowhere.
that evening,
Like his
that you
life.
observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Fair answer.
Do you
He's your
recall
witness.
stating at any time during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
This is a
No.
good point. For the most part, he's been dunked on by his own witnesses.
And what did you think at that moment that you saw the operator of this vehicle reach down?
I was unsure.
Yeah. Good answer. Don't make anything up. Stay with what you know.
Do you recall in your interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
Okay, so he thought it might be a gun, and it wasn't. We got to
And
dismiss
where
this
did
case, Your
where
Honor.
did you observe the vehicle go after it had passed you?
I turned away after it passed me.
Do you recall what the operator of the vehicle was wearing at the time that it passed you?
I do not remember.
Do you recall
Operator
during
of the
your
vehicle,
interview
also
with law
called a
enforcement
driver
that evening,
when you're not pretending to be a lawyer.
stating that you thought the operator was wearing a black sweater or jacket as it drove past you?
If that is what is written.
Do you recall saying that?
Just say no.
No.
Just like Nancy Reagan tells you when you're testifying. Just say no.
And do you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
Do you live in a basement like I do and borrow your mom's car? He
And
was taking it to get
anyone present
inspected.
with you during your interview with law
They got
enforcement
that in
that
common.
Yes.
evening? And who was that?
My mother.
And do you recall what agency your interview was conducted by?
Yes.
And would you stay for the jury and the record?
The FBI.
The jury and the record. That's why he called him, because it's the FBI. Yeah, exactly. This young guy's doing great. He's just saying what he knows. If he doesn't know, doesn't recall. Boom.
Do you recall stating in your interview that evening with law enforcement that you heard a lot of gunshots?
Yes.
And do you recall,
I wonder what a lot of gunshots is in Wisconsin.
I think that's a little bit unfair to say,
A lot.
if you had to estimate where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And
Yeah,
when you
okay,
say
good
a
point.
lot
He's in
of
the
shots,
city.
what would you
It's-
describe as a lot
Our
of
neighbors shoot all the time, whenever they
Like
feel
a
like
full
it.
magazine.
10 o'clock at night, the guy's out there unloading. Yeah, this young guy's doing it right, which most of the witnesses have. You can see these are decent people just coming in to tell the truth, caught up in this disaster this guy's created. And as reported earlier, he's going to try to drag his mom in as his anchor witness to get him off, because she's going to say the detective lied and never came to the house, never knew it was her house. The video of him driving away in the car, which actually is her house, and the DA will be able to cross-examine her, say, but okay, but is that your house? And she'll have
Do
to
you
say, yeah,
recall
that'll be
seeing
that.
the vehicle that you observed crash into anything?
No.
I tell you, if you look at the video of
Do you
the
recall
parade
stating
before
in
the
your,
crash or
interview
for his
with law
attack,
enforcement that evening that
it
the
certainly looks
vehicle
like
appeared
that.
to slow down
Just people trying to have a
while
good day,
traveling down
being decent to
Prospect
each other.
Court?
Yes.
He did have a supporter earlier who was butthurt that his
At
examination
some
of Erica
time
was
after
closed down.
observing this vehicle, did you call
Oh,
911?
Lord. Did I
Yes.
block this person? Not
Do you
interested
recall
in your
around what
private
time you called
photo.
911?
No.
Do you recall shortly after seeing this vehicle texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Nice.
Do you recall telling her there's a shooting?
Possibly.
So he calls a guy who thought there might have been a shooting because he didn't shoot anybody, and that's going to help him. How? Yeah, certainly when you're coaching up a witness, you want them to, and I don't think this guy was coached at all, but when you do,
No.
you want it to be clear, not expansive, just answer the question.
But you do recall seeing the operator wearing a black sweater.
I don't remember.
Nice.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
You know, what's the point of this unless he's going to say it wasn't me, which he didn't indicate in his opening statement. This kid's yawning now. The adrenaline rush is gone. He's got Brooks' number. He knows he's a loser. Let's get through this nonsense and get out.
Do you recall why you
Get back to the
gave,
chess club.
A description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
Owned.
And how did that person look?
I don't remember.
Nice.
Grounds.
It was asked and answered.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any
Devastating to the prosecution's case,
Yes, sir.
obviously.
You may step down and you are
Be
excused.
surprised that the judge doesn't dismiss all charges at this point. Excellent. Direct exam by Brooks, as he seems well satisfied with what he has accomplished and
Right,
his
go ahead,
evil
call your
grin
witness.
occurring.
And when we get to the next break, I have
Legal issue.
something to discuss outside of the presence of the jury. If that pleases the court.
Do you want to do that now or before?
Lots of phrases.
Can.
All right, I'll address a legal issue and we'll bring the jury back in when we're ready. All rise for the jury, please.
Giving that jury another break. They get their 10,000 steps in for the day. Unlocking a badge on their Fitbit. Yeah, so he does this act where he's acting like he's well prepared, knows everything, purposefully asking questions of these witnesses.
Everyone can have a seat and then we'll just wait for the door to close. Go ahead, Mr. Brooks.
I wish I could have read the logo on her mug. Her life-affirming coffee mug.
Curious.
He's curious.
Some of these, judging by the reports, how are some of these answers allowed to pass when
No.
they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question.
Yeah, because
You-
it's dumb.
I'm not sure what
The
you're asking.
report is hearsay, you idiot.
What I'm asking is, reading from the report
Yes.
that the people on the stand are giving,
No.
the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how.
No.
I just to be blunt, which I've been since the beginning of this trial, obviously.
Totally unfair, isn't it?
I see the whole strategy here by the prosecution.
Look at
I
him.
see right through it.
Look at him.
Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain
Well, he
things.
could have asked that. He could have
That
asked
is
whether they
completely
talked.
speculative
Yeah.
on your part without
It's
any
obvious.
basis in law or fact.
Obvious.
Why didn't you ask the guy?
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that.
Another
So for
reason
you
to not ask
say that right
cross-examination
now
is when the
without
other party
basis.
calls a case that completely
want
helps
to-
your
It's
case.
clear.
Why
If you
cross-examine?
are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any
I don't
more
think I have
legal
to- I don't
advice
think I have
further
to-
than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike
Really?
your testimony based on your
I didn't say
perceived,
anything
then that's,
about that.
all right, then I'm going to bring the jury back out and you're going to call your next
So the
witness.
strategy of the prosecution is to not ask
I'm not
cross-
hearing a request from you
cross-exam
at this time.
because
You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to
not cross-exam.
coach the
You're
people getting on the
assuming they
stand?
spoke to them and
Yeah.
coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
I do
Again,
too.
You could ask
You are
questions to
stupid.
lay a
All of
foundation
a sudden, the
with
state
these
don't got.
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up.
No,
We
it's
just gonna
because
not- we just gonna let these.
You asked all the
Well,
great
this is
questions they could have
argument.
Come on,
asked.
man. That's,
This is argument on your
I
part,
see
sir. It
through
is pure
I
commentary
just
at
want
this
that on the
point.
record. I see through it.
And your
Nice try,
see-through,
but I see through it.
Legal
has
strategy expert
absolutely
Darrell
no
Brooks has
basis
seen
in
through the
the fact.
I know
prosecution
that's what's
strategy
being
of
done.
not asking
you
questions of
ask
witnesses
these
who
you
were
can
already
ask
asked
these
questions that
the
made
right
their
witnesses
case for
certain
them.
questions, and
I'm
you're
far,
not.
I'm far from an idiot.
They're your witnesses,
You are far
sir.
from an
You
idiot.
believe-
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross.
No, but you can ask them
if
if-
coached to answer
Sure.
the way they answer.
Ask
because
You can't
that.
ask that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone
Right,
ahead
yeah.
of their
I find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it
Yeah.
very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on, man.
avoid the commentary when
Comes
the jury
COVID
goes
danger
out.
is
You
returning.
forfeit your right to be
I didn't say
present.
nothing. You.
Before we do that, there's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
Yeah,
That's not how it was said. I
That was how I
completely
said. You want to
disagree.
run the record back?
that's how it should be
Mr. Brooks.
said.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me,
witness
so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I accept for value, return for value.
Except for
It's,
value,
document.
return for
One more
value.
interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
He's so
It's not
stupid.
what I want to do. Do not interrupt Attorney Opera.
So can
Your
you?
Honor,
So
I
can you
believe he
please-
has 7 prior criminal convictions via OWI second from
Just slammed
1997
something.
and OWI third
Hopefully
from
not his Bible.
1997 and OWI
His family
fourth
Bible.
from 2003.
Look at him. You
criminal
think he
trespass
doesn't want
dwelling
to
from
murder people?
2006.
All right, I
Look
need
at this
to take
guy.
a break. This man right now is having a stare down with me. It's
Yep.
very disrespectful. He pounded his
Look at
fist.
him.
Frankly, it makes me scared. And we're taking a break.
Look at him. He did this the other day where he would not blink. I don't know. I would have said the last thing she said, but if that's how she feels, she feels. But that's what he intends. He intends to scare people, particularly women, if he can, intimidate. That's what he's about. That's his life story. So I don't know if she's going to take him out of the courtroom or just wait till he settles down a little bit. Yeah, he did this the other day, and I watched it as long as they showed him. And I tried to not blink myself so I wouldn't miss him blinking, because it was apparent that what he was doing was staring directly at the judge without blinking to try and intimidate her. And, of course, that's what he was doing here as well. So, like I say, a lot of times with these defendants, you don't get a look directly at their character because they're represented by attorneys, and it's kind of watered down to some degree. And for, I guess, some good reasons, you don't see actually the horrible things they do because they don't show that on the TV or streams, the horrific evidence. And so it's watered down a little bit, and you wonder who could do that. Is it really so bad and all that? And this guy, I think you can see he has trouble controlling himself under any circumstances. And if he had the physical edge on somebody, which for him apparently is the women that he gets around, he'll use it. Punch, hit, as Erica said earlier today, smack them, punch them in the mouth, take their money and things like that. And here he would really like to do in the judge if he could. Yeah, for the rest of his life, however long that's going to be. The judge did say that she was scared by what he did because of he slammed his fist down and staring right at him. And of course, I guess he knows his witnesses aren't helping him, but the prosecution isn't asking her cross-exam, because why would they? Because these witnesses are great. So I don't know. When I went to airborne school, they asked if we had any questions. We were doing some training, and the guy said, yeah, because we did reserve shoot training. And the guy asked the black hat, what do you do if your reserve chute doesn't open? And the guy said, well, you can pull it back in and throw it back out again. You can twist it, pull it, blow on it. You do whatever you want to do. You got the rest of your life to figure it out. And that was funny because they had dumped a dummy off the 250-foot tower with somebody screaming through a megaphone to show just how fast you'll get down to the ground without your parachute. And that was a good joke, and pointed out, it came to my mind because when you said the rest of his life, I'm hoping that comports with that sort of situation where it's not a long one. Instead, very short would be my preference for how he should be dealt with. But again, maybe he'll conflict with the wrong kind of people in prison and get back a little bit of what he's given out to the world. So, kind of extraordinary way for this case to proceed. Who knows what's going to happen with it? Again, I don't think, I thought this would drag into Monday, and it might drag into Tuesday for closing arguments as he makes a ludicrous legal arguments that he makes, and there's still got to be some discussion over jury instructions and things like that. And, he could drag it to Tuesday, say, for closing arguments, and then, the jury gets it, whatever, late Tuesday or Wednesday. But it could go faster if these witnesses are going quite rapidly, because he's calling witnesses that completely support the state's case, ask them questions that pull out that support, and then the state says, well, we don't have any questions then. And that means he doesn't get any redirect, which why would he? Because he just got done asking questions, and so the case goes fast. And for some reason, he gets angry that the state is not asking his witnesses cross-exam questions. So that's a new one for me. Your Honor, the other side is not trying to beat me. They're just sitting there letting me call my witnesses unimpeded, right? Like hypothetically, you would love it if a judge would say, as a sanction, when the other side calls their witnesses, I'm not going to let you cross-exam. In theory, that would be bad for your case, right? And that's what he's complaining about, is saying they're not cross-examining people. He sees through this brilliant strategy that they have of not cross-examining the witnesses that he's calling, when it's obvious the reason is because they're just good witnesses for the state. And for the most part, some of them have no real material knowledge of what happened anyway, other than they just incidentally saw him, like the nervous lady and the chess kid that was just up there. So let's see. So is there a sentencing trial, or will the judge impose a time of verdict? I will have to look it up to see exactly what the procedure is, whether it's discretionary or this, that, or the other, to see how much delay there will be in it. But and therefore whether it could be the sentence be handed down shortly after the verdict. So I'm not sure about that. I'm going to look that up too. Under the theory that he gets convicted of intentional homicide, I'll look it up and see how they handle that, because I think that is life without parole. There may be no discretion in that. It just depends on what. Every state's different, and I haven't looked it up, so I don't know what they'll do up there. But sometimes if it is discretionary, then they may, have a hearing after that, so the judge can hear evidence from the victim impact, where you can say things you couldn't say in the trial, and the defense side can say things they didn't say in the trial. So after they pretended that he didn't do it for a long time, then they can say, well, he did it, but he was bullied when he was a kid, or his parents yelled at him, or something like that, and try and establish some mitigating circumstances. And an extreme example of that, of course, is down there in Parkland, where they had the death penalty phase of that trial, which went on for a ludicrous amount of time, really to nobody's benefit in the end, just a waste. So, but I will see if I can check that out. I don't know if I'll get it today, because we're got some stuff happening this afternoon, getting ready to head out of town, but I'll have some research time after that, I'm sure, and kind of curious too what will be the result of this. Now that we're getting close to the end of testimony, what's going to happen? Because I think probably most people, at least I don't imagine the jury will take too long with this. The only lengthy thing to me could be the fact they got to answer so many charges, with like 70 charges or something. And so if you are going to read through those and understand it, it could take a while. And to make sure that you're not doing contradictory things and discuss it and sort of that. So if I were his defense attorney and I were trying to get him out of a mandatory life without parole and into some level of years, and with the level of charges, I don't know if it makes a lot of difference or not. I think his defender was going, because I think they were going to have an accident reconstruction expert and something like that. And so I figured what they were trying to do there was say, there's evidence that this wasn't intentional. And it's the state's burden to prove that it was intentional. So, you can sometimes attack it that way and say, well, they just didn't meet their burden of proof. That's kind of the weakest argument that you want to make, because what you want to tell the jury is that it didn't happen, not that it wasn't proved, because that sounds a little weaker, right? You want to show that it didn't happen. But either way, that's what I would try and do. I would line up this, well, he honked the horn, he panicked, it was a sudden break. There's no indication that all this evidence of what he did prior during the day, that clearly he wasn't lining up to drive into that parade in the afternoon. He was busy trying to get money. He was having this conflict with his girlfriend. That was primarily what was on his mind. So there was no pre-planning for this attack on the parade. Again, if you're listening to this, this is a notional hypothetical defense of intentionality, because I don't think there's any case for him not having done this intentionally. But if you were making the case, he goes down this road. It's confusing. A lot of people didn't even know there was a parade that day. He didn't know. He ended up on the course when he didn't mean to be. And from there, it's going to get really tough, because he honks his horn. So, okay, great. So he's trying to warn people out of the way. Then he starts hitting people. And if you hit one accidentally, maybe it was the crowd and you didn't get your foot on the brake and stuff like that, and it wasn't an intentional homicide. But he keeps on hitting people, keeps on putting people on the roof of his car. He just keeps on hitting people. I guess with a straight face, and this is one reason why I was never a defense attorney, you would have to attempt to argue in some way, and maybe you'd have like a psychiatrist or something say he wasn't insane, but he had a mental block. He wasn't insane. He was in control of what he was doing, but he lost his ability to understand and to react, right? So that it was a horrible, frightening situation, and people were making loud noises, and he was panicked and strobing lights, and he was getting shot at. And so, yes, he was in control of the vehicle. Yes, it was reckless and all that, but it wasn't intentional murder. It wasn't intentional that he meant to kill these people. He was only meaning to flee from the scene. He didn't mean to kill anybody. I guess that be kind of an argument for this. I haven't spent any time thinking about how to defend the guy, because to me, he's so clearly guilty. I've thought a lot more about other things I'd like to do to him than defend him. But maybe something like that. So here's a problem. If you do ask the one sole question of his witness, hypothetically, he can redirect, and then the judge can limit that redirect. But as long as you don't ask a cross-exam question, well, there's two things there. If you don't ask cross-exam, it does suggest one of two things to the jury. One is, this witness was so terrible for us, if I try and cross-examine him, it's just going to get worse and I want him out of here. Or they were so great for us, I don't need to ask any questions, and it is that one. The other thing is, if you don't ask any questions, he doesn't get to redirect and the person leaves immediately. This seems to be what he was butthurt about, is that the state's not asking any cross-exam questions. So the witness comes on, Brooks asks his questions, the people leave. And completely opposite to normal reality, that makes him butthurt. But again, if he had anybody who was supporting his case, perhaps they would cross-exam. Like hypothetically, he's going to call his mother to testify. And if you're the DA, there are things that you could get from her that would be terrible for him, not directly about the murder piece, but the fact that he called her for an Uber that night, the fact that the vehicle did belong to her, he'd used it before. Maybe you can even get her to admit that video, admit he took it that night. Who knows, right? So you could go to work on her a little bit incidental to this. And if you do it in a sensitive way, you're not attacking his mother. You maybe can feel sorry for her too, because she is probably, I don't know this, she's probably another victim of his. Whether he's a victim of hers or not, I don't know. But earlier she had said in an interview that that she thought he should be punished in some way for what he'd done, and she felt for the families who had lost and understood that pain, and that he had always had these mental issues and didn't get the help he needed, but that she understood people's reaction to him and thought he should have a punishment. That's what she said in an interview. So, that doesn't, to me, cry out that she's a monster too. I don't know, one way or the other. I don't have an opinion on anybody in his family. Why would I? They could be left out of it if he would leave them out of it. So who knows, right? So I don't know. That would be somebody that could get cross-examined, because she could hypothetically say something nice for him, because according to him, she's going to say the detective lied on the stand and committed perjury when he said he talked to her about and went to her house or maybe something like that and talked to the mom to get this video. And he's going to say that never happened. So yeah, so he's saying he's going to call his mother as a witness. That's exactly right. Yeah, so once you're down in the recklessness piece, you're into years of judgment, and whether it's concurrent or consecutive and this, that, or the other, who knows. But with so many charges, I don't know that it matters a whole lot. But they certainly want the life without parole, because that removes the possibility of parole. And also, it makes a statement about what he did do, which was he murdered these people. He killed these people. He doesn't care that he did, right? He doesn't care. He doesn't care about the child that the brain was severed from their spinal column and became an organ donor. He doesn't care. He doesn't care about the witness who said that she saw her friend with blood pouring from her mouth, and the medics trying to get her heart started again, when he was like, well, how do you know she was dead? You're not the doctor or whatever. He didn't show any empathy, any sympathy. He only showed sadness when he talked about the impact that this had on him, and how people on social media were calling him a monster. And there's two sides to every coin and that sort of thing. Not really. I don't think there's another side to this one. So yeah, parades are loud. Horn honking doesn't mean as much. And that's true. There's a vehicle is unusual coming at you. Now, he's going to say, well, hey, I beat the horn, and that meant I was trying to warn people to get out of the way. Okay, but where do you go with that theory? Like, if you're sitting there able to beat the horn because you see this parade in front of you and people aren't out of your way, the next move isn't to hit the accelerator and just run over them, which is what he did do. He even had a police officer banging on the hood of his car. I don't know why he did what he did. Did he want to murder these people, or did he not care that he was going to run over them and essentially intentionally cause their death because he wanted to get away, thinking he'd be arrested for beating his girlfriend? Who knows what this loser thinks at that point in time. Apparently, maybe he did honk his horn, according to some of the witnesses. So I could see him in rage hitting a horn, and when people don't move out of the way, in his world, they get what they get. If you just saw how he was staring at the judge, I don't think you can hesitate to believe that this guy could form the intent to murder somebody within moments. Within moments. He doesn't need a 6-month plan of building up rage against somebody, long-term relationship to develop a hatred to somebody to murder him. He decided he wanted to kill the judge there just a few minutes ago. It's pretty obvious from his expression to me. And I think this is a really good point here, that he may be insulted they aren't cross-examining his witnesses, because it implies he hasn't made points that need to be crossed and insults his perceived intelligence. Yeah, his ego and self-centeredness seems to activate his behavior sometimes in a negative way, whether it's beating women, which is something he not only does because he's angry, but he seems to enjoy it as well, or whatever. But this comment makes a lot of sense to me as to why he may have gotten suddenly butthurt and then wanted to let everybody in the courtroom know that he sees through this master legal strategy of not questioning his witnesses. Okay. Yep. I like it when he has the mask off, when he feels like the COVID is at a level of acceptable risk transmission that he can have his mask off. Then you can see what a horrible, evil expression he puts on his face when he wants to. And it's harder to see sometimes when he's wearing that mask. You can't see that he's pure evil. So I do like that they have the additional purifiers in the courtroom, giving him the assurance he needs to sometimes remove his mask so that you can just see just how horrible he is. Because again, he's a safety guy. Like I say, he's a safety guy. He had that mask on when he was being interrogated after he murdered all these people. So he either got it from the police or he carried one with him and had it on, had it down at the chin, which again reduces the effectiveness of the mask, but it still shows you care, and he wants you to know that he cares. And as we said, CDC advises that you wear a mask when you're beating women or murdering people, because that can cause aerosol transmission of viruses. And it's just something, as a practical matter, you want to remain safe while murdering or beating people. And he takes that seriously. He sees through this. He's not gonna be railroaded. So I kind of agree with this from the standpoint that I feel like she shouldn't give this guy any leverage to think that he scores points against authority. On the other hand, she's a human being reacting in the moment, and gave, I'm sure, an honest assessment of how she felt about that. I mean, I would like her to laugh at him because that probably would hurt his feelings, make him ultra butthurt. So, find an angle where the cameras don't catch it. Mock him. That would be my immature desire to do. But instead, she's acting like a professional, and I think gave her honest assessment. Yeah, but I do agree. I think more authority against this guy rather than less, but I won't second guess her in her moment there. And I agree with this, and we watched this together and looked at it and kind of in shock that, what? I mean, what? I guess what? But did he really cry? Somebody else, I think, pointed out they didn't see any actual tears from this guy. And it's interesting. I didn't watch it closely enough to see that. But having said that, I think everything except for concern for himself that he does is fake. The concern for himself is real. He wants, on impulse, what he wants, right? And if he doesn't get it, he reacts. If he perceives an insult to his ego, as we talked about a minute ago, he reacts. Escalates quickly. Very quickly. If he can't make an intellectual argument for it, which he might put forth and he might not, then if he needs to do it, he'll be violent. He was violent with Erica when she didn't have the money he wanted and punched her and smacked her in the face. I think looking at him is pretty clear what he would like to do in that courtroom. If he were the one in charge of what's going on, what would he do? And so you consider that when he's on trial, how he's behaving, right? And somebody mentioned earlier, which I agree, his kids are going to see this at some point, and it's terrible. But imagine how he's behaved when the cameras are not around. What have people seen from him? How terrified has he made people? How many bad things has this guy done? It's hard to say. Yeah, one good idea when there's a parade in front of you, you could honk and stop, or you could just stop and figure out what's going on. But honking and not stopping is a really bad option. That's really bad. And eventually running over and injuring, 60-some people is kind of about the worst option. I mean, it could have been worse, I suppose, but it seems like he made it about as bad as he could, speed-wise, as well as maneuvering the car around to hit people. And maybe that moment he broke and his murderous rage was at its maximum, And if he could kill somebody, he would do it because he just gotten done smacking the girlfriend. And he was further disrespected because the other guy, the temporary labor guy from yesterday, intervened and was telling him, you need to get out of here. Well, he did. He got out of there. Got in his truck, turned it around, went to the parade route, ran over these people. So sometimes people lose control that are like that, and they want to hurt people, and they don't put any limit on it, and he didn't. And to some degree, Erica, I guess, she's lucky to be alive, I suppose. Because, he has injured her previously, and they have not allowed the jury to know that. They have not allowed testimony about that in the courtroom. And he was trying to use that earlier today, acting like there's no reason for her to be afraid when witnesses were having to dodge around the fact that the previous beater and assaulter, that he would try to imply that there was something shady going on with their testimony, something shady going on with Erica's testimony, and yet it remained the case that was continued to be outside the jury's knowledge. It never was allowed for his previous bad acts to come in. And usually in a criminal case that is limited. It's hard to get that in depending on the circumstances. But the idea is that it's unfairly prejudicial, not just that it's prejudicial. It's unfairly prejudicial because if you show he beat her once, the jury could very easily conclude he beat her again. And so the idea is he should be judged on the facts of this new case, not the one. So sometimes if you want prior bad acts in, you got to show like some kind of common key signature things that you did and stuff like that to show that it was more likely you than someone else, and not just that you did these other things. It's not just prejudicial because the whole goal of putting your evidence on is to prejudice the other side's case. It has to be, quote unquote, unfairly prejudicial. That the probative value to the case is outweighed by the unfair prejudice that would be involved in allowing that testimony. So he could have swung around in the other direction if he'd opened the door more. But the judge is hesitant for that because she doesn't want this to be set up to be reversed. Full respect to her for that. He does think he can open the door just in his direction. He was mystified. And why couldn't he mock Erica? Why couldn't he attack her credibility? And how could you think that if he did that he should possibly be faced with the jury knowing that his history is beating people? Yeah, the temp guy taking the jacket off to throw down, that's pretty awesome. I think I called it a samurai jacket yesterday, but since we're still on this break, I don't want to bore you guys too much, but when I was in the Army, I knew this Samoan guy who was a huge dude, and his theory was if he got his shirt off, there was a fight. And so if things ever got sideways enough and you saw him started taking his shirt off, if you were his friend, which I was his friend, he never wanted to fight me, thank God, or I wouldn't be doing this live stream. You could try and prevent him from completing taking his shirt off, calm things down a little bit. And because of the size of the guy, the shirt coming off was sometimes all the warning the other side needed anyway to create the space to reduce the conflict. So the temp guy saying, when I throw my jacket down, it's on. Respect to him for that. And he didn't look like any kind of big guy to me, so also respected he would take the opportunity to stand up for Erica and be a friend to her. I think that seemed to me pretty genuine how he was and his feelings on the situation. Yeah, I like this. We need to swear the temp guy. I would swear the temp guy in as a bailiff and put him in charge of the shocking button. That's what I would do. Then I would call the IT director back, have all the cameras turned off. I wouldn't really do that. I would do something worse if I could. But that would be a good solution. I would like that. And I think he should be a bailiff in charge of the shock button for this Joker. And what is going on right now, right? Like, there's no way, I think, that the judge needs this long to regain composure. So, and here we go. So here we go. It's back. And he is back into the Bible again. He's a weird one, man. He's not a guy that has to blink a lot. He did just do it once, so that shows his murderous rage has been reduced a little bit. courtroom. There she is. Sheriff with the Glock. You know, this dude was shot at 3 times, and one of them went through the windshield from behind, I think. And what can you really say about that? Unfortunate waste of lead. I mean, I like due process and all, but violence is often the answer in the real world, and we just forego it by agreement. But there are still circumstances where you could see where it should be applied. Yeah, I feel like he's not absorbing much of that Bible there, many parts, but there's a lot of violence in the Bible too, though. You can just pick out the parts you like, depending on which side you want to be on, of course, I guess. Yep, a tactic agreement has been formed.
Before.
This will be interesting. I'm sure the jury's out.
I'd like to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness.
You weirdo. You freak.
I trust that you're ready to do that, sir.
He doesn't have to if it's a tactic agreement.
Oh, we do. I knew I would left something in my office, but I reviewed it, so go ahead. What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's...
Well, we do have a photographer in the courtroom again.
And obviously that would not have been a crime, but everything from OWI second on down we believe would be appropriate. There's also one that's noted, 06CM2039.
She seems to have a giant lens too. I wonder if they just share that lens or if they all have to buy their own. It'd be good to be a lens salesperson around that courtroom, because that's a big one. You can't be cheap.
Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
90609.
Thank you.
Yeah, that looks like a pretty serious lens to me too.
To the defendant.
It was. It has not been discussed with Mr. Lozano.
That was going to be kind of my next topic once, thank you, I look at this again.
You know, law and crime to me at work, I have some issue with them on some things, but mostly not, because they present these trials for the public to view, and I think that's a good service to do.
Mr. Brooks, do you have a position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of
normally you would use that for
questioning
impeachment.
the witness, whether that's by you or by them if they so choose.
Call your own witness and impeach your own witness. What?
And that would be
Does
for
he
a
even know
determination
what the hell's
under
going on?
90609.
Okay. Okay.
What?
What?
I don't know what you're asking.
Mr. Brooks, you may recall at some point, I believe we had a discussion about prior convictions.
7's a lot.
I think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't
Boom.
No, there was one state's witness that had one prior that
Yeah, I remember
we
that.
discussed. in
That's
the court
right.
rule.
We did.
Like when he was a kid, he walked on the
Recall.
construction site.
So at that point, I directed your attention to
He didn't steal
90609.
anything. He was just trespassing. Like,
And then I made a
20 or
ruling based
something.
upon the factors that are enumerated in that statute. You've been provided with a listing of the record I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
In theory, if you call the witness, you would argue, well, I don't want them to be able to ask about these prior convictions, right? Because it impeaches the person. But he calls witnesses that are good for the state, so maybe he would want to impeach the person. I think that's what the state is trying to say.
Looks like it's 9 on here.
Which is the one the state referenced, that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039, 2 times violate harassment/restraining order, and then it says DM/RI, which means dismissed and read in, 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So no convictions from that.
This could be a buddy, though. It's many times he's been to jail.
So why is it on the sheet?
Lord have mercy.
This would be an accurate listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
You have to know what you're looking at, dude. And he probably does.
And nothing since
His rap sheet is longer than his rap song.
2007.
That's correct.
All right. Any statement you want to make, sir?
Oh, he wants to make a
What the number of
statement.
convictions this court should consider under 90609.
Yeah, I don't know if it's his rapper buddy or
Dismissed
not.
and read in. Does that mean there was no charge?
No, it means it was
What's that word on his hand? Is that blow?
when there was a conviction for something else,
I think his
the charge was dismissed and
other
read in,
hand has 100%
and
on
then the
it.
court considered it
You
at
know
the
what he
time of
means by that?
sentencing. So they are not convictions, but it was a case, so that's why, my understanding why it was listed.
Wonder how many people's EBT cards he had to sell to afford those tattoos.
So where it says dismissed and read in, that would be the restraining order and the
Restraining orders, bail jumping. This could be a buddy of his.
Right, misdemeanor bail jumping, so 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
I'm not sure if he understands what she's asking, though, or why she's asking it. You know, this is really about who's going to impeach this guy. So the side that he doesn't benefit would want to impeach him.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it, that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
Oh, that's a very good point here. Very good point.
So there's no crime for OWI?
An OWI first would not be a crime, it would be a forfeiture.
For him, having to answer to a woman that he can't beat is a dystopian nightmare of unparalleled horror.
I still would say 8, just based on the fact that there's continued OWIs
Okay, sounds good.
all the way up to a 5th.
I do note the COVID transmission risk has increased, and Mr. Brooks has put his mask back
the
on.
parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any
It's not even as good killing mask.
argument that it should be less than that?
Less than what, 8?
Well, it'd be less than 7.
That's
He has
awesome.
7
It is awesome.
convictions as I count them.
Emotional support mask. He's very distressed about whether this is 7 or 8.
OWI first.
Correct, because it's not a crime, it can't be counted under the statute.
Then it's 7.
Which is where we started, ladies and
7.
gentlemen. Should have
Right.
said 7 when you said
Do you want to
7.
make any argument about whether any should be excluded under the statute? Based upon the factors I just read to you.
Well, you already made reference to one of them not being a crime. So that brings it to 8. I don't understand the whole...
Well, for example, the last conviction was in 2007, it's now 2022. So do you want to make an argument to the court that perhaps...
Depends.
he's
This
been
guy may be
rehabilitated?
terrible for Brooks, and Brooks would want to bring in the convictions. To say, Your Honor, this witness I called is terrible. It's devastating to my case.
I don't want to speculate on the next man's life. But if it's 7 on here...
He really all he wants
I
to
guess
do is
it
argue, and
brings
he's
it to
looking for a
7.
cue from the judge of which way she wants to go so he can say the opposite way.
Whether
all he
OWI
wants.
first is not a crime, it still counts as what it essentially is nowhere to get to 2, 3, 4, and 5 without the first. Looks like 7 to me.
All right, then.
Criminal
anything
record
further
specialist Darrell Brooks
from the state
has
on-
decided the appropriate number is 7.
Given the number of
Lucky number
convictions,
7.
Factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that, you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007.
I think this comment applies to most
That
things
spans
he
about a
does.
10-year time span.
But it's a witness he's about
It's
to
now
call who has a
2022.
criminal record.
But there's essentially
discussion
agreement
about
by the
whether
parties that there are
that
7
can be
convictions
revealed or not.
that are listed
The
here.
number of convictions, at least.
I've looked at the lapse of time
Which in
since the
theory
convictions.
goes to the credibility of the
I
witness.
don't know about
So in theory,
rehabilitation
if
or
it's a
pardon,
witness good
other
for
than
Brooks,
it looks like
he should not
did
want it to come
complete
in.
the earned release program.
But
which would
I
have
feel like the
resulted
state brought it
in
up,
a
not
reduction
because they
of
intend to
the
impeach this guy,
initial
because there's
confinement,
probably another guy that's great
and
for
then
them.
converted to
So
extended
he impeached
supervision.
his
I
own
did
witness.
see, violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony,
Here we go.
that this witness has 7 convictions.
So then somebody can
He
say,
may be
do you have
asked,
7
have you been
convictions, bro?
convicted of a
And he
crime?
can
His
say,
answer should be
I don't know, I
yes.
thought it was 9.
The follow-up, how many times, the answer.
And then they
will
can
be
say, well,
7.
we just spent an hour on worldwide TV talking about whether you
Before he
had 7
testifies,
convictions or
Your Honor, I
9
believe.
and discussed your entire criminal record in front of the whole
I agree.
world.
State willing to relay that information.
And then there'll be 10 crimes
I'd
after
rather
that.
not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it be Mr.
Oh.
Lascano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
I don't know. That wouldn't
All-
surprise me,
well,
but I don't know. Haven't
For
heard
sure,
it.
Mr. Hayes and Mr. Lascano, and I'm not sure, the 3:30 witnesses, I think, are probably on their way. They're on their way,
All right, so Hayes and Lascano are still here.
yes.
All right.
Let's
Those
get
are the
one
two
of
who
'em.
are here, sir. I'll tell you what, either way, let's just bring Mr. Lascano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please.
Sweet.
Can I have a first name for this witness, please?
It's
Abel, thank
Abel,
you.
but I believe it's pronounced a different way. It's A-B-E-L.
He doesn't consent to it being pronounced that way, potentially.
Abel, thank you.
Abel.
Subject matter jurisdiction, Your Honor.
Oh, Lord.
Court declines to address that.
Still has yet to be verified and proven for the record.
Your objection's noted.
And,
For the record.
Unfortunately, under Illinois versus Allen, the Supreme Court did not clarify that the trial judge can
You
tell
want
the
Mr. Lozano on
defendant,
the
this
stand,
is
or
really
you're gonna call
stupid
Mr.
and dumb.
Hastings? Just so I know what to do when he comes in.
I don't currently have, I can't find paperwork from Mr. Hayes. Can a police
Who
report or
cares,
something
man?
be provided in case I
No.
want to call Mr. Hayes first?
Yes, we will accommodate that request. It'll just take me a minute, Your Honor, to find it. I'll have to have it printed and brought over, or Mr. Witchow can run. Thank you, Mr.
I will give you
Witchow.
permission to email it to Teresa and she can print it in the courtroom.
Well-
That will assist.
It's part of a 700-page PDF, so I can't just email one page.
Sweet.
I see.
At least I don't know how to do that. Copy and paste it into a Word document.
Oh, yeah. Let's go tech.
That's all right. You can do it the way that you need to.
And you see here, Brooks again. This is terrible.
Mr. Loscano, I'm just
It's
gonna
hard
have
on
you, for a moment.
He hasn't been able to beat anybody.
Take a seat.
Some
You're
time
not
now.
gonna testify just yet, but just come up and take a seat, just at the end of my jury box for now. I'm not gonna have you come up to the witness stand. I want to, everyone can have a seat. I want to advise you that, I'm
This
aware
guy's
you
so
have
stupid.
a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how
Yeah,
many
they
times?
should.
The answer to that is 7. Have you heard me say that?
I believe it is a
Understand
stupid sovereign
All right,
citizen
thank you.
argument.
I'm not sure that you
I do
need
believe
context, but I
that's
wanted
what he's
to do
doing
that
there.
if I didn't have
Part of the whole.
You can go back.
I don't recognize that name. Third-party
Thank you.
intervener, subject matter jurisdiction. Only a living, breathing human can have a criminal complaint. State of Wisconsin's an entity, not a person. All that stupid
All
stuff
right,
that
then
he
let's
got
have
off
the
of
jury brought out, please.
some blog somewhere. I did have a sovereign citizen employee one time tell me they didn't want taxes taken out anymore because they weren't under the jurisdiction of the IRS, this, that, and the other. And I said, well, in that case, I shouldn't pay you with federal currency because that's the only way I could do it. And then we reached an agreement that we just do it the normal way. He could be a sovereign citizen in other ways. Yeah, sovereign idiots are, any little thing they think they can make up that has no basis in anything,
All rise.
just do it. So yeah, he's complained about capital letters, and then she said, well, what if it wasn't capitalized? And he said, well, that wouldn't matter anyway. And she said, well, what name do you want to go by? And he wouldn't answer that. I don't know here. He of course he's asked for the case to be dismissed many times, so that is what he would like. He'd like to have some legal argument that would result in him going free so he can go back into the wild and enjoy beating and killing people again. It's just for the things that he really enjoyed in life. Yeah. Acquittal would be tougher. His argument to the jury I shouldn't say argument, his
Thank you,
opening
everyone.
statement
Please be seated.
just said, you'll
The
learn
defense
this
may call
wasn't
its next
intentional or
witness.
planned. I don't know. And you also learn that he's a big crybaby, which we hadn't really seen him do that before because he's a big, tough dude when it comes to beating women like Erica Patterson, who's quite a small woman. COVID risk transmission quite high. The mask is on again.
We'll have the witness brought in.
The deputy back there is the extreme risk. Oh, no. He's got to reach for this other box. God. And see, kids out there thinking about being a mass murderer, these are the details they don't tell you when they try to make it look so
Is it Haynes or
glamorous.
Hayes?
All the boxes you got to move around, the shackles, the shock collars, the COVID transmission,
Good afternoon, sir. If
the
you would
Bible
please
you
make
have to
your
pretend
way
to
the
read.
witness
There's a
stand.
lot more to being a mass
Right.
murderer than you would think.
Upper riser.
It's not all
When
glitz
you
and
stand
glamour.
Please remain standing. Raise your right hand. My clerk, Teresa.
Sometimes women tell you what to
Will swear
do.
you in.
It's terrible.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat.
If I were going to impeach him, it would be on the
First thing
basis
I will
of,
ask you to
do you know
is
what
to
year it is?
state
Why are you still
your
wearing one of
first
those
and
weird
last names
bracelets?
for the record and spell each.
Weird kind of rubber plastic bracelets.
Jason, Jason, Hayes, Hayes.
Thank you. Go ahead, sir. Your witness.
Just 1 second.
Hey, Hayes. I'm curious about his mother, too, whether she'll be the anchor witness he hopes she'll be. Well, she said he's always been mentally ill and didn't get the help he needs, but he should face some repercussions.
Value this document.
Except for value in return for value.
Good
See, the
afternoon,
serial
Mr.
murderers,
Hayes.
they're glamorized more
Is
than the
that
mass
how you pronounce
killers.
Hayes?
Yep.
Mass killers do the work more quickly and
do for a
efficiently, but rarely get the publicity of a serial killer.
Sales associate for a food broker, Damon Worldwide,
Been doing
Food
that for
broker.
a long time?
21 years.
Yeah, it's a long time.
All right. Cool.
The
Yeah,
evening of
that's what
November
she has said. I
21st,
hope she sticks with it.
2021, you recall that evening pretty well?
Fairly well, yes.
Yeah, exactly. And that he was mentally unwell or whatever.
What were you doing that evening?
Watching you kill people?
Went to the parade.
Did you go to the parade with family, friends?
I went there with my daughter.
I went with my mortal enemies.
Do
We
you
get together
recall
once a
what
year,
time you
go to
arrived?
parade together.
30 minutes before the parade started.
Damn. That's ex-military or something. If you're not early, you're
Were
late.
you scheduled to do any marching in the parade itself,
No.
or just
No.
spectating?
Just acrobatics and things. The food broker, he was in charge of hot dog bun supply.
Yes,
Thank
that's
you.
what I thought he said.
Yeah.
Or whatever they
I
eat
just
in
wanted to make
Wisconsin. I don't
sure.
know. I think they eat weird
Yes.
things in Wisconsin, don't they? Cheese stuff or whatever. I don't know. Oh, got it. I've got to believe that's a
Anything
no on
unusual
this
catch
one,
your eye
given
that
this
day
guy's
that you recall?
demeanor.
Yes.
And what did you see?
Besides the parade,
Yeah.
Yeah. Yeah. Remember when I drove my
that was
mom's
the
SUV
usual
over those
catch your eye.
kids? That was a good one, wasn't it?
well, where we were, yes, a red truck came through
Mm-hmm.
where we were.
And you were in it.
It honked and swerved.
I guess I want to back up a little bit.
You always
were
want to back up a
positioned
little bit.
at that
We
time?
were all the way at the beginning of the parade.
Okay.
COVID transmission risk has reduced to an
Main
acceptable
and-
level.
Corner of Main and
Brooks
White
able
Rock.
to remove his mask.
And you said you observed this vehicle honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it, I guess the correct question would be, why did it swerve?
How would you know that?
I don't know. I wasn't driving. I don't know what his.
I wasn't
intentions
murdering
were.
people. Another stellar witness for the defense. Will there be a lengthy cross-exam? I don't think so.
You stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
Or was it a beep 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 boop bop
do you
boop?
recall stating that it
More of a
honked
jazz
several
kind
times?
of honking?
I
Boop
don't
bop
recall.
boop
You were
boop bop.
initially
I don't recall.
Or was it a kind of a hip hop kind of a honk? I don't know.
well, before we get to
What
that,
is this guy's point? This is just Mountain Dew. This
Did you
isn't.
see where the vehicle went
Real
after
drink.
it honked and swerved?
Yes, it kept on going straight down Main.
Thank you,
East.
Kelly. I really appreciate that.
Same route to the
Put it to
parade
use
went.
this weekend to get over this thing.
Did you get a description of who was driving the vehicle you saw that
I
night?
did not.
No.
Did you get a license plate?
I did not.
Did you see any
recall if the
tents?
vehicle had any tinted windows?
No.
See any tents?
And I'm assuming at some point you were
Cheese and
or
beer.
you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did, by a detective.
And do you recall if that was the same evening or
It was not the same evening.
so it was,
It was a
that-
couple days
prior?
after.
Okay. Do you recall in that interview that you had with the detective stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes,
So in your opinion, it wasn't trying to strike the kids?
correct, yes.
So this is the first time he's actually, to my knowledge, brought up a point that supports his theory.
And after it continued, I think you said east.
Yep,
Would that be correct? East.
yep.
Did you see the vehicle strike anyone? When
I
you...
did not, no.
So he has actually called a witness who supports that at least in this first instance, he wasn't trying to kill these kids. Yeah, and of course he did kill other kids
Do you
later.
recall what side of the street the vehicle was traveling on?
But at least this
It was on the
is the
right
first
side.
witness who isn't devastating to him.
So we were on the north side of the road.
That would be awesome.
So the right side would be.
Yep.
Okay. Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes,
So you never saw it go to the other side of the road or?
no.
I think this is a good point. I mean, if he were smart, if this were the good point he wanted to get out of this guy, he should stop, because you remember that, right? If he goes down some other sidebars, it's probably not going to get better. Don't sell past the sale, man. You got 1 point finally.
Further questions at
There it
this
is.
Thank you. Any cross?
All right, Clarence
Yes,
Darrow
just briefly.
for the
Good
defense.
afternoon, Mr. Hayes.
Good afternoon.
Here comes a
Thank you for
cross,
your
devastating
attendance, sir.
cross. This will make Brooks happy.
Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's a cross. You may answer.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes,
Objection.
Is that,
Objection, this hurts my case.
I guess the objection to be what officer is being referred to.
It doesn't
Was it
matter.
clear?
It's just, did you remember saying it?
Overruled. The statement continue asking the
Could be
question.
officer friendly.
I guess I was asking was that referring to the
You can
interview
do it on
officer?
redirect, baby.
Objection is noted. It's overruled. The statement asked the question fully.
is that your recollection, sir, that the vehicle sped off and accelerated away?
yes,
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the
Oops.
driver of the vehicle had a dark complexion and a beard?
yes,
Now remember, a few
Is that
minutes ago,
accurate with
Brooks
your
wanted
recollection of the driver?
the DA to CX.
But you didn't see a face?
How's that
you
working out?
No.
How's that working out for you,
Beyond
old Brooksy?
those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Redirect?
Thank you. Any redirects, sir?
Briefly.
Briefly, Your Honor. Please the court.
Very
This honorable chamber. Uh-oh, I'm getting a spin here. Let me hit a pause and I don't know if that's my computer or not. Here it comes. Kind of.
The defense may call its next witness.
That was
please.
it then. Watch a few more minutes of this.
Quick
We're
question
getting
before
off.
I do. Who's supposed to be arriving at 3:30? Just so I know.
This is like a calming, zen-like portion of the trial.
Idiots and Darrell will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
This last few minutes was
Who's
almost
here now?
sane.
Just trying to get clarity.
Trying to get the
Are
clarity.
you going to call Mr. Liscano?
It would appear so. He's the one that's here.
All right, then he may. The defense is calling Abel Liscano, correct?
The defense is calling Abel Liscano.
He's your witness.
We'll have him brought in. Thank you.
He doesn't consent to that name. Or at least not his name being screwed up like that. So this next guy is the guy that had all the convictions they
Good
were.
afternoon, sir. If you would
having a
please
bizarre
make your
argument
way
about a
to
few
the
minutes ago.
witness stand. When you get there, please remain standing. Raise your right hand. And my clerk Teresa, who will be across from you or is across from you, will swear you in. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing
Everybody
I will
bringing
have
their
you
own
do is
water
to
today.
State your first and last names for the record and spell each.
Abel Liscano, ABEL-LAZCANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Liscano. What do you do for a living currently?
I'm a hairdresser.
Didn't see that coming. Did not
No judgment whatsoever on this question.
see it coming. Okay.
Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Okay.
Do you recall the night of November 21st, 2021 pretty well?
Got
It's
past
been a
that.
minute, but
Best as I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade? Or,
No, I was watching it.
who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
I was standing in front of the Corey Insurance on Main Street.
Okay. Is that part of Main Street close to like a side street?
It's
If you recall?
not too far from Maple.
Yeah, he does
Do you
that a
recall
lot.
the side streets being barricaded during the parade?
I don't remember.
Do you recall what time you arrived at the parade that evening?
It had just started, so whatever time that was at.
You recall something other than the parade catching your attention that day?
You mean when you killed everybody?
People getting hurt, yeah.
Yeah. Thank you, Abel.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
Finally, somebody telling it like it is.
Did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
Sweet. Nice. His witness, too.
And how many people did you see in the vehicle?
Just one, the driver.
So, do you recall
So he called a witness who identifies him as the
flagging
driver of
down
the
a
vehicle
law enforcement vehicle that evening?
that plowed over people.
And do you recall what you told the officer that evening?
Not very well.
I'm gonna attempt to see if anything brings back some recollection.
So
First,
the last witness was a fluke. He is
name of the
making an
officer
actual
you,
point.
flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
This is stupid, of course, because there's videos of the SUV of him driving it. If it was a clown SUV full of 25 clowns in it, he's still the guy driving it.
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
He stopped with all this. Do you see the
And
plaintiff
do
in
you
the
remember
room
what
and
the
stuff?
description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
And it's you.
Is that all you recall about your description?
That's all I remember.
I kind of remember precisely it was you. So why would you call this guy if you're Brooks? What are you doing here? You called the witness and he said, yeah, I
After
just watched
seeing
you
this
plow over
vehicle,
everybody.
what did you do?
We left. I got my family out of there.
Yeah. It's fair.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
I believe it's the Lindholm or what building. It's on Maple Street.
Yeah, these are pointless questions here. Maybe his theory is if I make the prosecution's case better than they
And
do,
did you see the
then I
vehicle
should get
stop
whatever I
on Maple
want.
Street?
I win.
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop. No.
No, I was too busy intentionally killing people.
And speaking with, is it Detective Moss? Well, speaking with law enforcement that evening, do you recall advising law
Yeah, if
enforcement
he'd done it right, he could have done the refresh
that you observed 3
recollection
black
kind of thing.
subjects running from the vehicle?
But he's kind of doing it just reading from it. Everybody knows he's reading from a police report.
If it pleases the court, I would like to
Well, let's see what he does.
show the witness this. I'm referring to page 4 exactly.
Is it a statement this witness personally wrote?
I believe it's with,
No.
I don't think he wrote it himself.
So it's a summary written by another person.
By, I don't know if it's Officer Moss or Detective Moss. I'm not sure what his rank is.
Continue with your questions. I'm going to deny the request that you show the exhibit or the paperwork to the witness.
But I mean, he's been reading from it. Everybody knows it. He just said that's what he's reading from. And the guy said, "No, I don't remember it." So he's kind of done that.
Do you recall making the statements to Detective Moss that you observed one where it says one was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that
Yeah, see, I
the
don't know
other
if
two were described
these are
as running
exhibits
in a
already or
westerly
whether the
direction
law
from
enforcement
the rear of
previously testified, yeah, I
338
talked to
Maple
this
Street?
guy and he told me this or any of this stuff. I just don't know.
Do you recall stating that one black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as two short black males wearing sweatpants?
Barely, a little bit of that.
A little bit of this, a little bit of that.
Which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him.
You just got dunked on.
I remember.
So where did you observe those?
Standing by the vehicle.
If you look at that
Found
pin
the
Brooks
when I
has to
spotted
hold,
it.
doesn't it look like it's just the refill part of the pin? Maybe they don't give him the hard plastic part so he doesn't stab anybody in the eye or anything. I don't know. This looks like a
Just so we
flimsy
have
thing to be
clearly
a pin.
describe the subjects you saw that evening standing by the vehicle.
I don't remember that good.
Nice.
I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
Sweet.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
I was walking my family back to the car. Trying to get them to safety. So I was keeping an eye out and I spotted it.
Nice.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No. When I found it, it was parked already.
Okay. Sometimes I think this too, and I wonder if he really swallows his own sovereign
Do
idiot
you
nonsense.
recall when you initially had the interaction with Detective Moss?
Some people do.
Do you recall leading him to where the vehicle was ultimately found?
Yeah.
Nice.
Do you recall yelling at subjects standing outside of a building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
Not sure what the point is right now. I think he's just walking through this police report. For For no discernible reason.
Do you recall why the report says that
I can even recall why a
you
report he didn't
advised
write said something.
Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
But remember, the vehicle's parked, and maybe they did go up and look at it and ran away because they didn't want to be part of this crime scene. What's that got to do with anything? Uh-oh. It's running out of steam.
Were you yourself injured in this incident that evening?
No.
Oh, he's going old school. Were you yourself injured? Not were you injured. It's making it longer. Let's be a little more procedural. Law and Order, Special Idiots Unit. It's keeping that momentum going.
Do you recall stating that, well, let me back up for
Yeah,
a
let's
minute.
just back it up a little bit.
Did you speak with another detective that evening, if you recall?
Yes, I did.
Okay.
Do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening.
Yeah, not 2 of the same law enforcement officers. 2 different law enforcement officers. It's an important distinction.
Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your interview with Detective Coates that evening stating
He's
that
just walking through
you
the
could
paperwork.
not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. And there was at least 3 or 4 more on the
See, he
floor.
asked this question too many times. Now this guy's
By
curb
the vehicle,
stomping
it
him.
must have been the ones trying to hide the vehicle because they were standing
Right.
in front
Just
of it or
cleared it
real
up.
close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast.
Yeah, just
and they
been
were
devastating
standing around
attack. Everybody's nervous. You
them. They were the only
idiot.
ones not doing much.
Mm-hmm.
So yeah, they stood out.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or
that's
4 people
crazy.
in the Ford Escape as it
That
passed
whole
you
situation is
during
crazy.
the parade that evening?
No, I don't remember that.
Any reason why the detective coach would report that that's what you stated to him?
Like I said
Objection.
before, I saw
Done.
two or three people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade.
See,
I saw
he's
the
cleaned
driver
up
going
why he
by
thinks this.
because he hit somebody right in front of us.
Nice. Cleaned it up nice. So he kind of had a point a little bit, but
Do you recall
kind of, but not really.
in
But now
your-
he has nothing.
interview with the detective coach that evening stating that the three individuals, and I'm referring to who you saw next to the vehicle, so it's clarification. The three individuals who were standing in a line, shoulder to shoulder, as African American males.
Yeah.
Okay.
So it's fair to say that's what you observed that evening?
I saw at least two of them. And looked like they were standing in front of it.
This guy's been pretty good, pretty solid. Hairstylist Abel. Doing a good job on the stand. Brooks, to me, just appears to be walking through the police reports. Just when he reads something, he
And
turns it into a
during
question.
that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming
You're the older one.
one of the individuals that you saw standing shoulder to
Do you
shoulder.
remember
was-
Detective Coates
was,
writing end of
older
report?
Yeah, I don't remember.
Why would he write end of report at the end of it? Darrell has gone low energy after his murderous rage outburst a little while ago. Abella's like, what's happening here? Is this real life? Why is this nut calling me as a witness? I saw him kill people. What's happening here? And I'm with him on that.
Any reason why multiple, well, I'm not going to say multiple, two. Any reason why the two detectives that you spoke with that night both reported that you stated you saw three black subjects running from the vehicle?
No.
Math boy feels multiple would be too imprecise and goes with a more precise two. Law enforcement officers.
And during the parade incident, were you or anyone you were with injured that evening?
No.
No further questions at this time.
At this time.
Thank you, any cross?
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
Good afternoon.
Another
Sir,
Brooks pleasing cross exam
You
in
said
progress.
you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes? Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection leading.
Overrule, Ms. Cross.
No, I don't.
Speculative. Objection.
That's dumb.
Overrule. The witness may answer, I believe he said no, his answer may
Yeah,
say.
no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection. Speculative.
It's not speculative.
About how many people did you see the SUV strike, sir?
Objection. Speculative.
Overrule.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way.
Nice.
So it got to in front of us, then it actually hit somebody, and it just did like a cartwheel in the air.
You remember that?
Yeah, it was right in front of us.
Okay.
Pretty strong accounting here.
Giving the answer, not the last answer, but the one prior to that, he had his right hand in the air, directioning, his
So
hand
Abel's
from
got
right
quite a
to
criminal
left,
record, but as you can see in Wisconsin,
describing,
even
the
people with
vehicle coming
significant
from right
criminal
to
records
left.
will come forward,
And then when he
do their
said,
civic duty, tell the
he saw
truth
someone
about
going in
this
the air, he
idiot
was
here.
twirling his fingers as if to say it kind of tumbled in the air.
So in some sense, he's unified the community.
So, Mr. Liscano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
Now, remember a little while ago, Brooks went bonkers because he said these people were being coached. And so he was going to ask, did you discuss any of this with the DA's office or
Objection to
something?
the
But he never did do
relevancy
that.
of Exhibit 65.
That's done and is overruled.
Noted, overruled. It's been received. The state may proceed.
All right, this total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's
Yeah.
shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection
Okay.
speculative.
Overruled. His answer may stand, he said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
I see the green dot.
Yeah.
Objection leading.
Overruled.
It's cross. You can lead.
You may answer.
Yes.
That looks right, correct, sir?
Objection leading.
Overruled.
All right, we're gonna clear the screen, please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled.
That's
You may play the
crazy.
clip.
Overruled on what grounds, Your Honor?
There it goes. Wasn't that it? It turned in up at the top of the screen.
Is that a tacit agreement?
Tacit agreement. There you go.
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
No, I did not.
Okay. Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Yeah.
Okay.
And then on the porch, there was maybe 3 or 4 or more people. I don't know if they were, I'm sure they were white, but
Okay.
I was trying to not make it obvious because at the time, I believe that they were with the vehicle. So
Yeah.
I didn't want them to see that I saw them. So I
Yeah.
just
He's trying to get his family
did what
out
I thought was
safely.
right at the time.
Sure.
This guy's been pretty
Do you
straightforward.
happen to know the people that live at this house?
Good witness.
Objection speculative.
Overruled.
It's not
No, I
speculative.
didn't.
You idiot. He
Would
either
it be
knows or he
reasonable,
doesn't.
do you think, Mr. Lescano, that people living in the house heard the crash and came outside?
Now we're getting
That's who you saw standing there by the
speculative.
vehicle?
Objection. There was never any crash mentioned.
I'll sustain.
Yeah.
Calls for speculation.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area, is that correct?
Objection mischaracterization of testimony.
Overruled.
Yes, there was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection speculative.
Overruled. The witness may answer.
Yes.
Yep.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Okay.
Brooks very frustrated. He's not allowed to kill people.
You said on
As part of his defense.
direct
He would like to be able to assault
examination
the judge
that you
who
saw
killed
the
people at will.
driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection,
Is this how she's going to close it out?
Overruled.
Yes, he's sitting right over there.
Are you
Kaboom.
sure about that, sir?
Yes.
Objection. Speculative.
Overruled.
That's dumb.
You
That
said that.
mischaracterizes the testimony because
No,
that
it
was
doesn't.
not testified to before on direct.
Then how could it
Your
mischaracterize it, you
objections
idiot?
are overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't
No,
see
I
it at
didn't
all?
have to be looking up at the top of the video
Just
to
wondering.
catch it.
Mr. Liscano, have you and I ever spoken about
I
this
think it
case,
was.
sir?
No.
No coaching.
What about Attorney Basie here to my right? You and her ever talk about this case through your testimony?
Objection, hearsay.
Overruled.
No.
Dumb.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection, hearsay.
Objection. Random word.
Overruled.
No, man.
All right, thank you, sir. I don't have any other questions.
Redirect.
Thank you. Any
Very
redirect?
briefly, Your Honor.
Yep.
If it pleases the
Go
court, it's honorable judicial system.
You stated that you saw the driver, correct?
Yep.
Of the SUV that you saw that day, correct?
Yes.
And how did the driver look that day you saw him?
Like a
He had
big old
scruffy
butthole.
beard, and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance? Tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street.
Well, that's an interesting view switch
I
there.
didn't pay attention to the color of clothes you were wearing. I knew it was a black male. And
Just
I was
anticipating being booted out of the
First thing I told
courtroom.
my wife is he was a black guy driving.
Back in the game. So he's arguing with a witness that he called about how sure he is that he saw him. And this guy had not otherwise testified. That's where you want to be in your case. You want to be disputing your own witnesses. That shows an integrity to the jury. Sure, they put on 25
recall how
witnesses that saw
long
me do this, but
you were
here's
able to
15
get
more.
Side view, as you called it, of the alleged driver?
Alleged
A
driver.
couple seconds.
And in a couple seconds' time, you were able to make out the driver's profile and race just by a couple seconds.
I
Yeah.
mean, how long does that take?
It's not hard.
Yeah, thank you, Abel.
They tell if you were white or if you were black and if you had a beard. No, that's it. I don't know what color shirt you had on.
This guy's
You
spitting
had
truth.
hair, a hat on backwards.
Exactly. Don't know if you made a
So that
dumb
leads back to the
rap
question
video with your
of-
mom's truck.
Is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's the
fair,
only reason.
would it be fair to say that
Abel's powering through.
when you spoke with 2 different detectives that evening,
Because this guy doesn't have a
Evening of
fingernail
the
clipper in
parade.
jail. What's he doing here?
both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you?
Well, he said why he thought that.
Is that fair to say?
Oh, wait, can you repeat that again?
Yeah, because it was done.
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
2 different
Yes,
ones.
I did.
Not 2 of the same.
And both detectives that you spoke with that evening, the evening of November 21st, 2021,
You stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Yeah.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle.
Bell's got this on lock.
I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives, 2 different detectives.
Sometimes I get the idea he's just never happy.
2021.
Oh, Brooks is just never content.
And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade, why both detectives in their reports
So at some
stated
point, ask and
told
answer,
them
right? I know you don't like
that
his
you
answer,
observed
but
3
you
or
keep
4
asking the same
people in the
question. The
SUV
DA
at
should say,
the
come on,
time of the
objection.
parade.
So what's your question?
Yeah,
The question
we've
is,
all asked that.
why did you report that to 2 different detectives?
He's told you
On the
like
same
500
evening.
times.
Like I told you before.
Even the court
I
reporter's
walked
like,
past
come
the
on.
vehicle. I spotted more than one individual standing
She's
in front of the vehicle.
doing some control C,
So I
control
assumed they
V.
were with the vehicle. That's why I said they were inside.
I'm
Yeah.
sorry.
That's why I said
You
they
don't have
were.
to be sorry about
They
this
were in the
'cause you're
vehicle.
dumb.
I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
Now, come on, DA, shut this
So
off.
why would you report that you saw this during the parade?
I don't know.
He didn't write the report.
And during both interviews with detectives that evening, the evening of November 21st, 2021,
Uh-huh,
you also stated to both detectives
right.
that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why
I didn't
both
object to this, 'cause
detectives
come on.
reported that you said that?
How many times you
No,
can
I don't
ask about the same thing over and over?
No further questions.
Thank
Thank
the
you, sir.
Lord
You may
above.
sit Do we have additional witnesses here?
Yes, Your Honor, they're ready.
All right, would that be how many people?
There's 2 left.
Okay.
Wow.
So the 2 left on your list, your next witness, sir.
All right, guys, I'm gonna have to cut out after
So I'm
this was
guessing
finished, so this was pretty entertaining. Crazy stuff. I will try and find out, I don't know if it'll be tonight,
One
but,
quick second, Your Honor. One quick second.
about what happens when the jury decides, assuming there's a guilty verdict, and what goes on with the sentencing. Kind of curious about that too. But appreciate everybody that came into the broadcast, and I hope you all have a good weekend, and that Darrell Brooks has a bad weekend, and that justice is done in this case. Thanks, guys.